Hearty welcome to Jnanarjane Empowering Excellence. Friends, we have arranged this 2 days private trust workshop. On Friday, we learned the formation and governance of private trust. Today, we have at another very interesting topic, Fema issues relating to private trust and income tax issues relating to private trust. To enlighten us on these two topics, we have eminent chartered accountants Mumbai. They are really busy with their routine work and so many other knowledge sharing. And even though when we invited them, they are happily agreed, even on the festival mood, still they agreed and accepted our invitation. They have joined us on behalf of Bangalore branch and on behalf of all the participants here. Hearty welcome to CA Rashmin Sanghvi, sir. Hearty welcome, sir. On behalf of Bangalore branch and on behalf of all the participants here, hearty welcome to CA Rutvik Sanghvi. Hearty welcome, Rutvik.
Thank you. Thank you very much.
Friends, they are going to enlighten us on the topic Fema and income tax. And friends, you are the reason for this program. This succession planning is actually my favorite subject because in Bangalore, not many are practicing in detail. That is the reason we thought it appropriate to have it in Bangalore in detail. Last time we had a detailed succession planning program workshop. Again, this time we conducted only specifically private trust. This is again a very confusing topic, but after studying that, it is not that difficult. Better we learn in detail and apply wherever it is required. In that reason, we have arranged this 2 days workshop on private trust alone. With that note, you have shown interest. Your active participation makes this program a successful one. Hearty welcome to each one of you, friends. I'll take a minute of yours to update about the upcoming program. On 16th, 17th, and 18th, 3 days program on information technology workshop. Again, it is a very interesting upcoming opportunity for chartered accountants. I request each one of you to register that program. Please visit bangalore.icai.org. There are many programs lined up. Another at least I think 17 programs are lined up for this month. Please visit bangalore.icai.org and understand and know all the new programs for the benefit of our members. Please look into it and register. With that note, once again, hearty welcome to each one of you. Over to Divya.
Thank you, Chairman, sir. Very warm good evening to all the participants and to both the speakers of today's program. We have with us CA Rashmin Sanghvi, sir, to give a brief introduction about him. His partner in Rashmin Sanghvi Associate and is practicing as chartered accountant in Mumbai since the year 1975. His areas of interest are international taxation, foreign exchange management, water management, and philosophy. He was appointed by CPE on e-commerce committee in the year 1999. He was also appointed on e-commerce committee in year 2015. He has also written a couple of very interesting books that is published at Taxman. With this very brief introduction, I wholeheartedly welcome.
I can't hear anything.
Yeah, exactly. Even I am not able to hear.
For today. 1 second, I'll switch off the video. Maybe some signal. Now, am I audible, sir?
Yes.
Yes.
So, members, to give a brief introduction about Rutvik Sanghvi, sir, he is a chartered accountant with more than 15 years of post-qualification experience and is also partnered with Rashmin Sanghvi Associates. He is involved in the firm's core international tax and foreign exchange regulatory advisory service areas. His focus areas are inbound and outbound strategy and many other related topics. For this very brief introduction, I also welcome you for today's program, sir.
Thank you.
Welcome to you.
Thank you. Should I go ahead?
Oh, yes, sir. You can start. Yes, sir, please.
Okay. Yeah. I hope everyone is able to hear me right clearly. Yeah. Good afternoon, friends. A very, very, warm welcome to all participants. Being a religious holidays which are going on, with being a Saturday, and even then, all of you are attending. uh, is good. This itself is also quite important in a ways. The reason being that there is a dearth of straightforward provisions on this topic, and I would take this opportunity to thank Bengaluru branch of SIRC of ICI for considering me to take up this topic. It was a huge benefit for me personally to again relook at all the provisions, to study the provisions, and to bring them out the intricate issues on them to all of you here. I will not take up much more time. What I will do is that I will just try to cover up wherever what issues are important on this topic. Before that, please do feel free. I know that this is not a personal, personal meeting. We would have definitely preferred that. However, to make up for that, please do post your queries onto the Q&A box. And as time permits, I will try to take up the queries. But before I start, I do need to acknowledge the immense contribution which I have received from my father, Mr. Rashmin Sanghvi, who is also on the panel today with me. My immense luck in that sense, because he is there on the panel with me, I have to rest assured that I can cover up. I can do what I wish and support me as he has always done so. I also would be failing if I do not acknowledge the benefit that I have of the intense research which has been done by my senior partner CA Naresh Ajwani on this topic. His papers are available on our website on this very topic, and my presentation is nothing but an offshoot of those papers and his study. So, with those acknowledgements, let me start with Fema and private trusts. I understand that earlier basic overview of the trust law and legal issues related to trust and how to use them for succession have already dealt with on 9, which is where I will not go into those areas, largely speaking, unless necessary to bring it in context of FEMA provisions. Therefore, my presentation is largely split into a general overview, then how FEMA will apply to private trusts, what are the legal issues, certain case studies dealing with those issues, and certain practical issues which one must be aware of. So going into the overview, I understand that this is not a seminar on FEMA, and therefore I would take a few minutes to explain and briefly take you through what FEMA law itself has to be looked at, or how it has to be looked at, how it has to be interpreted. In our view, FEMA is not policy law, regulatory, sorry, not a revenue law, but a policy law. And what do we mean by that? We mean that it relates to the government's policy of certain things, whether to be allowed or not allowed, certain transactions to be allowed or not allowed, certain activities, certain holdings. In a cross-border situation, you do come and encounter FEMA in each and every case, largely speaking, and therefore their mindset can change, and therefore it remains to a law which is always subject to change as per the government and the RBI's thinking. There have been in such instances have made a decision, drafted it into law, and over a few years later they have changed those positions but not made a change in law, which is one drastic situation. There is another situation where they have overnight changed the provisions of law to counter the thinking what they have of the current manner. So in these kind of cases, what happens is that you have a dynamic law. I understand you will say that yes, why not? Income tax also keeps on changing, generally speaking, on a year-to-year basis. But in the last couple of years, we have at least seen them changing the Income Tax Act also multiple times a year. Must bear in mind is the fact that there is still some sort of a structure, and that structure continues, and there are amendments made to whatever the provisions are. Here, if there are amendments under FEMA law, it means that something which was earlier allowed may get disallowed, something which was earlier disallowed may get allowed, and therefore you have to be on your toes. You have to be current with what the thinking is, current with what the practice is. In fact, till a few years back, the circulars were being issued on a daily basis, and it could become a task to keep updating the law to factor in all those changes in the provisions. We today have benefits of publications which keep on updating those things, but even then, one must understand that it is not a precise and a very very well drafted law. It's a very very important law. Almost every issue. However, at the same time, it is not a law which is easily understandable. And why do I say that? It is not that it is some rocket science. The problem is in how it is spread over, how the vastness of the provisions are spread over several provisions of the Act, the notifications. You may sometimes have to look at the directions. You may also have to look at FAQs. And even though they are not legally binding, there are certain clarificatory issues which are there only in the FAQs. And over and above all, there is certain practices which for certain times RBI believes that those practices are the norm. However, they are not, and there are people who have had setbacks because they are not aware of the practice, but they go by the book. So this is Fema is an act which I would probably say that opening the book and giving an advice would not be very very sound unless you are very clear that the statement made in the books or statement made in the act and the provisions is in line with what the RBI's policy or the government's policy is. You can always interpret income tax to the nth level. You can always say that no, this comma here means so and so, and that particular semicolon means something else. Adjustum generis. A lot of issues are there for interpretation of a tax law like Income Tax Act or a GST provision. However, FEMA does not have that kind of a leeway. You must also understand that FEMA has no appellate system inbuilt. You cannot today say that, okay, fine, I will take an action based on my understanding. And if that does not get approved, then I will fight for it till I go to the Supreme Court. No, there is no appellate basis at all you can have an appellate mechanism under SEBI laws. You can have appellate mechanisms obviously under the Income Tax Act and the GST, but you do not have that similar privilege under the FEMA. And therefore, if at all you have to challenge it, you have to straight go to the High Court. That is not the cup of tea for, I'm sure, several of our clients and several of the business houses and industrialists who would not like to pick up a fight with RBI. So to bring it in context, you have to have a understanding of FEMA's practice and what RBI looks at it in certain manners, and try to be as far as conservative as possible. By which I mean there is something which is not allowed or not permitted, you may end up violating the FEMA if you go ahead and assume that just because it is not mentioned, it is allowed. No, it is not that. Silence is not a consent as far as this FEMA law is concerned. If they are silent about something, it only means that the drafting is loose. You may have to go ahead and seek an approval, a permission. You may have to discuss with the ED banks concerned. They may also be, direct you in an incorrect manner, and therefore finally the ball lies in the RBI's court. Again, there has been a sea change from here. Now we have so many managers in RBI who are there, who do have knowledge of FEMA, but they do not have the whole tradition or the historical outlook of FEMA in some cases. And therefore, they may also look at FEMA only from a bookish perspective. And therefore, you may end up saying that the FEMA, sometimes that the RBI itself holds the wrong view. And today is one such instance where I will probably take you through that kind of an instance. However, that means that it does not mean that you may exercise a loophole or you may go ahead and do something which may still remain as a violation, because there is no time limit under FEMA. A transaction which is a violative transaction may be picked up 5 years, 10 years, 16 years at the time when you want to exit that investment, at the time when you are looking at a quick takeover by another company, is when all those issues will come to the head. At that stage, they will say that no, this was something which doesn't look right, and therefore you have to go to RBI, get a compounding process done. And God forbid, if this also is not available, then you may go into the doors of the Enforcement Directorate, which somebody would not wish to go through. So therefore, in sum and substance, my view would be that wherever there is a FEMA provision, please look at it, understand the concept, understand the reason why it is so and so there, and what is the current view on that understanding if there is a gray area as far as certain provisions are concerned. And why do I ask you, why do I tell it in so much detail today? The reason being that private trust is such an issue. In any case, when you look at a private trust, the own Indian Trust Act, an act which has not changed since centuries now, if I go to say, and at the same time, the issues are not so clearly provided neither in the Indian Trust Act, neither in the Income Tax Act, and therefore we end up looking at trust in a either very loose manner or something where we end up having complicated structures. Therefore, one must always bear in mind that trust is something which is in itself an animal which is not yet fully known, not yet fully explored in a way. A lot of things under trust law go by way of practice. You will encounter issues where you have you have the REITs and the AIFs. All these kinds of structures are there which are going on since now decades. REITs being a new entity, a new entity, but there since a long time. SEBI has given full approvals to everyone, and still there may be some issues where you may encounter that they are not exactly sound as far as a trust law is concerned. But things are going on, things are being accepted, things are going on fine. So therefore, trust is something which is, I would put it this way, is an understanding which people accept and then move ahead. And if the regulatory authority which is concerned with that domain accepts it, then it goes ahead. Unfortunately for Fema, we don't have that. Fema, there is no clarity on how a private trust has to be dealt with. So what we have understood is that trust is an obligation. Trust is a relationship at best, and it is probably not a contract, and it is not probably a person also. It is not an entity in itself. We may tend to call it an entity. We may file an ITR 7 to say that, okay, yes, this is, I am filing a tax return for a trust. I have got a PAN card for a trust, but still it may not be treated as an entity as far as Fema is concerned. You may look at it under the Income Tax Act. Even there also, under the person's definition, trust is not covered. Same is the case with Fema also. And therefore, we come to the clarity. How do we judge a trust or transactions which lead to a creation of a trust? Once a trust is settled, then what the other transactions happen, how to deal with them? There are concerns, there are areas where you will not have answers. And therefore, what we have is a deadly cocktail. It is a mixture of an imperfect Fema, which does not have laws which are governing the private trust matter. And then you have a largely misunderstood trust law, because nobody has bothered to update the 1882 Indian Trust Act or to bring it into current, or to see the differences between the Indian Trust Act and what the foreign trust laws say. What is the general practice? All these things are not disclosed or not elaborated in detail into any kind of a provision by any regulatory authority or by any act of the parliament. Therefore, we are sitting on, I would put it this way, on hot coals. If you are taking a call based on just one reading of these provisions, I would probably say that no, please have a relook. Please consider those provisions only with a pinch of salt. Consider that whether this is workable or not workable, and whenever in doubt, ideally go for an approval to RBI, especially where Fema is concerned. We have several parties generally, and I'm sure you must have dealt with already on this on 9th of September. So I'm not going to bore you again with those details. My only concern is that when you have a settlor, generally speaking, the parties involved in a trust are a settlor, obviously, the person who settles the trust. There are beneficiaries for whom the benefit is there of the trust assets and the trust funds. The trustee, who is the legal owner and controls the trust funds and the trust assets for the benefit of the beneficiaries. The donor, in some cases where the settlor is not the person who gives the funds, the settlor is settles the trust, but then there are funds which come into the trust by way of a donation or a gift from the donor. And then finally, you have a protector, which is not a norm under the Indian Trust Act, but you do have these concepts under the foreign trusts, where a protector is somebody who protects the benefit of the beneficiaries, who sees to it that the trustees act in the manner and for the benefit of the beneficiaries. These are the various terms, and one must be aware of, and one must study those terms and be aware of how they are applied. My only concern is that as far as these terms are concerned, all of these terms have an issue as far as Fema is concerned. So one must be careful while drafting a trust deed, one must be careful while executing a trust deed, one must be careful while acting as either a trustee, beneficiary, or a settlor. And if full knowledge is not available, then to seek proper knowledge and proper confirmations before proceeding on any of the transactions. What are those concerns, or what are those Fema issues? Almost every aspect, as I already mentioned, is of a trust can lead to Fema issues. Let's take a few examples. We'll go into further details on the further slides. Is trust a person or an arrangement or a transaction? That itself is an issue first. And as I already mentioned to you, the definition of person under the Trust Act does not cover trust as a person. So what do we look at it? Is it a contract? Then no. Contract Act says that there has to be a consideration, and there is no consideration as far as trust is concerned. Trust imposes an obligation on the person acting as a trustee and provides a benefit for the beneficiaries. However, there is no consideration in lieu of that. Therefore, what is a trust being arrangement? However, to have that arrangement in place, there will be a series of transactions, and those transactions are where Fema comes into play. You may also look at the residential status of the settlor, trustee, or the beneficiary, because, as we all know, trust has the split ownership, a legal owner and a beneficial. Therefore, when you look at the residential status, whose residential status do you look at? Where, if today you ask me that where is this trust actually a resident of, it may be dependent on whose trust itself is. Whether I look at the status of a legal owner, the trustee, whether I look at the status of the beneficial owners, the beneficiaries, how do I look at it? Do I even go to the settlor? Do I consider at all the settlor in the picture once he has settled the trust? All these are question marks, and therefore one has to go in depth into studying whether how a private trust and what is formed and what are its elements. Again, there will be issues under Fema depending on where the assets are located. Are they in India or are they abroad? And bear in mind, we are not at all discussing in this whole session about anything violation of Fema. Having some assets which are under violation of Fema, and then to say that, okay, I want to go and create a trust is an impossibility to begin with. While we all know that, there have been very famous cases of trusts which are formed abroad for the benefit of, beneficiaries, say in India or in the reverse manner, we all know that that is a non-starter in place. In those cases, there can be a severe investigation and almost a surety that things will be taken in a bad manner, and things will be taken by the not only in some cases by the enforcement directorate. Today, we have moved ahead of all the past, information gaps, if we call that. People used to wonder that how will somebody know that I have a trust outside India? No, those days are gone. As soon as your personal identification is given anywhere outside India, there is a link which is created. Once that status is known, then the Indian government would know on an automatic exchange of information basis immediately. They don't have to wait for years now. They don't have to go and call for information. The most and the famous of the tax havens are happily giving information wherever required because they want to be now in the good books of all economies. And therefore, you may wonder that, okay, is there any chance left for this? We don't go into that discussion at all. What we discuss here is that there are assets probably properly under Fema, then how to structure a trust and how to avoid any pitfalls as far as Fema is concerned. As I mentioned in the end, better to be safe rather than sorry. The reason is that at the time of settlement, if, for example, you believe that there is no approval required under RBI, or say there is everything is hunky-dory and you don't need to take any, your interpretations are all valid, it may happen that at the time of distribution, you may come at a stumbling block. There have been questions which have been raised by banks also saying that, okay, why is this remittance being made? Where is this document? Is there an approval taken from RBI? And in some cases, we have seen personally that a trust which has been prepared and kept ready, and when actually the beneficiary really wants that trust as the distribution of blocked, they have to wait for months on end to get an approval from RBI because the RBI approval was not taken when actually that should have been taken. So therefore, keeping everything in mind, one must be proactive. One must deal with trust immediately, or rather the FEMA issues at the start itself, and not wait for events to happen. So let us come into the brass tacks of it, that how FEMA applies to the private trusts. What do we look at? One is that there is no specific provisions or clarification under FEMA for private trusts, as I have already mentioned to you. Only AIFs and other investment vehicles are allowed as and investment in the Schedule 4 of the NDI regulations for non-repatriable route, which is open to NRIs and OCI card holders. Again, there also they have allowed investment through a foreign trust. However, at the same time, the NDI regulations, the NDI meaning the non-debt instrument regulations, which mandate or which cover the foreign investment into India, they have very much clarified that an unincorporated or unregistered entity would not be allowed to invest into India. And to our knowledge, there is no such trust which is an incorporated or a registered entity, largely speaking. It could be registered, but definitely probably not incorporated. You may have a company under the trust, which is maybe an incorporated entity that can probably go ahead and invest into India. However, the trust by itself, whether it can invest into India, there is a serious question mark, even though under Schedule 4, there may have been some leeway given. Trust as a means of succession planning is allowed only as legally permissible, as I mentioned to you. FEMA applies to each transaction, and approval is required in all cases of the cross-border transactions where specifically no permission is given. But most important part of it is that what do we mean by a transaction? A transaction in a case of a private trust also includes the creation of a right or obligation or liabilities, and is not limited to only the remittances, transfers, or the investments. Please bear in mind. What happens is that often we come across where clients tell us that no, I will create a trust, and at that point of time, there is nothing which happens. It is only when the assets are supposed to be settled into the trust, or for that matter, in some cases, taking a view that no, only when the distribution of the assets or income happens from the trust to the beneficiaries is when RBI comes into play. If that is the understanding, then I'm sorry to say that is an incorrect understanding. Our understanding of the matter is that every and each transaction of cross-border nature, FEMA will come into play, and that begins straight with the settlement of trust. And what do we mean by, and why do we say that? Let us go through in slide detail. I'm sorry if I'm going fast. Is this fine?
Yeah, it is fine. It's going good.
Okay. Yeah. Thank you. So then we come back into how the FEMA applies. As I mentioned to you, it applies to each and every transaction. So what are the transactions which are covered under FEMA? There are two broad classifications: the current account transactions, which are generally allowed unless specifically prohibited, and capital account transactions, which are generally prohibited but allowed only if they are permissible. This is the clear, I would put it, that two mutually exclusive baskets of transactions. Either a transaction can be a current account transaction or a capital account transaction. It should fall in either one of them, and FEMA acts on each of such transactions. So you do need to review that what the transaction is happening when you are applying, when you are planning to have a trust. Then what kind of transaction is it? Is it a capital or a current account? Now, what does a capital account transaction means? It means a transaction which alters the assets or liabilities, including contingent liabilities. Please bear in mind, including contingent liabilities outside India of persons resident in India, or assets or liabilities in India of persons resident outside India, and then includes transactions referred to in 6.3. Now, what we are trying to say here is that they are saying that anything which alters the assets or liabilities of a resident vis-a-vis his assets outside India, as far as they are concerned, then it becomes a current account transaction. And if they are in assets or liabilities in India, the transaction which alters the assets and liabilities in India of persons who are resident outside India. So you have this full clear cross-border angle brought in a capital account transaction. If there is an alteration, assets or liabilities come into the picture of a current account or capital account transaction. So therefore, cross-border acquisition of holding an asset is a capital account transaction, Whether the acquisition is by way of purchase, gift, or inheritance, it doesn't matter. Here, RBI does not say that no, because you inherited and therefore my FEMA does not apply. No, that is not the case. In whichever way you acquire an asset, it becomes a capital account transaction. Obviously, transactions which are other than capital account transactions are known as current account transactions. But how do you distinguish between the two? And I'll borrow 2 minutes here, though related to directly, I would like to brief you about what will be the main distinction. Please bear in mind that capital account transaction and current account transactions, you don't go ahead with the bearing of accounting terminology. It is not exactly classified as what is classified as revenue and capital in nature. While it may be largely similar to it, but it is not the same. The whole idea here is that when you execute a capital account transaction, will it have, or whenever you execute a cross-border transaction, will it have an impact on India's foreign assets and liabilities position as an internationally, or will it get squared off? Therefore, if it gets squared off in the reasonable time which is supposed to be done, then it becomes a current account transaction. If it does not get squared off, if that alters the positions for India on an international landscape manner, or what we call it as a balance of positions as far as India is concerned, what is India's overall debt position to other countries or receivables as compared to other countries, in that kind of a sense, you would have a transaction which alters, which is considered as a capital account transaction. Therefore, when you come to a capital account transaction, unless it is specifically permitted by the rules and regulations, the assets may not be allowed to be transferred or held. I have just given a few examples here. Say, for example, which you have to import on a normal credit terms. Technically, in your accounting books, you will put it that yes, this is, for example, it is not a business in machine running, but you are in a factory, you are operating a factory and you bought a machine for that, then you would probably put it into as a capital asset. But bear in mind that if that import of machinery is made on normal credit terms and payment is made, if there's a 2-month credit terms and you have made off the payment in 2 months, it becomes a current account transaction as far as FEMA is concerned. However, if you say that you import the machinery on an installment basis and you have to keep on paying for that machine, then what have you created is that while you imported the machine, fine, but your obligation or liability now brings in qua a foreign non-resident, which means then that it becomes a capital account transaction and not allowed unless specifically permitted. Same goes for payment of a guarantee fee to a non-resident, but a guarantee which is provided by a resident outside India, again a capital account transaction. So if you're paying a fee, then that's a current account transaction. Matter ends as soon as I've paid the fee, there is no alteration of assets or liabilities. But if I pay a guarantee, if I have a guarantee which I provide to a non-resident, that becomes a contingent liability. Again, something which brings in FEMA and capital account transaction comes into place. Same way for foreign house, if I pay for payments of rental amounts. However, if I purchase, obviously it will be a capital account transaction. I import gold into India, current account transaction. It may sit on my capital assets list, no, but that's all right. It still remains a current account transaction because I've paid for it and I've got it into India. There is no alteration of assets or liabilities for me as a resident outside India. However, if the gold is purchased and kept in a locker abroad, it becomes a capital account transaction. Same way with interest payments and loans taken. So these are what I just wanted to give a brief glimpse of what is a distinction between a current and a capital account transaction. And the reason why it is important is, as I already mentioned to you, that current account transactions are generally freely allowed. However, capital account transactions are only specifically allowed. And if they have not been allowed, it means that you have to go for a permission from RBI. Why all this? As I already mentioned to you earlier, it comes into play because as soon as a trust is settled in favor of a beneficiary, there are rights and obligations which are created. Obligation qua the trustee, rights qua the beneficiary. If this is under a cross-border situation, you are bringing or inviting FEMA into the picture because there is a capital account transaction. What are the other provisions under FEMA where it applies and how FEMA applies? I'll just briefly take you through them. And by far, these are the substance. This is the substance of the FEMA legal issues. Let's look at first section 3 of FEMA. What does it say? Without a general or specific approval from RBI, no person can deal in or transfer any foreign exchange to anyone except an authorized person. No person can make any payment to or for the credit of any non-resident in any manner. No person cannot receive any payment from a non-resident in any manner except through banking channels by way of inward remittance. No person cannot enter into a financial transaction in India as consideration for acquisition or creation of a transfer or of a right to acquire any outside India by any. Now, this is obviously Hawala, the last part. But the other provisions are where you are getting stuck as far as a trust is concerned, because in the private trust, are you making any payment to or for the credit of a non-resident in any manner? Are you receiving any payment from a non-resident in any manner except through the banking channels? If so, that means that Section 3 of Fema itself does not allow you to do so. So this is where it applies as far as say an holding of an asset is concerned. Then your Section 4 of Fema, it says no person resident in India shall acquire, hold, own, possess or transfer any foreign exchange, foreign security or any immobile property situated outside India without a general or specific approval. Which means that if as a resident of India, I under a trust receive a property which is situated outside India, it is specifically offense. If not, I will have to go for a specific approval. That's the simplest approach which you are asked to take. Then you look at Section 8 of Fema. If any person is entitled to any foreign exchange, he should bring it back to India within the specified time. He cannot delay bringing it in the same. Which means that if you are eligible to receive any amount. So for example, I have taken every approval under RBI and I have got an asset under a trust outside India. However, the trust has some income and the trust distributes that income to me. I cannot say that no, you can reinvest about right now in India. You can reinvest it into the asset or some other asset. I don't want to do it. No, you have to get it back to India. Section 8 of Fema mandates you to get it back into India. While you may feel that these are such blanket prohibitions, RBI has permitted certain transactions under these sections 3, 4 or 8. However, there are many conditions attached to it. That's not always a simple way to go ahead and say that no, fine, this is what is allowed. And those conditions, if you are not meeting, or if your situation or transaction is not covered under 3, 4 and 8, it means you have to go for and get a specific approval from RBI. And then finally, what provision triggers under Section 6 of FEMA, which regulates the capital account transactions, which I just mentioned to you some time back. Now, in those is under capital, we'll have to look at Section 6, and under Section 6, the powers to it is given powers to RBI, which in case of non-debt instruments has been taken away from RBI to the central government, under which you have the NDI regulations. And therefore, you may have to look at NDI regulations to see whether you are allowed to do certain things or not. And if the trust is not allowed to do certain things, then you are back to square one. Under a capital account transaction, you have to go to RBI for a prior approval, without which you cannot proceed. Now that we have covered the major provisions of FEMA, let us look at certain guiding principles. How will you tackle when you look at private trust under FEMA? Whenever you have a cross-border kind of angle as far as a private trust is concerned, what do you look at? You look at the ultimate effect of the transaction. What do I mean by ultimate effect? I mean that you consider that what if the trust was not there? So today, if an Indian resident settler wants to put assets into the Indian trust for the benefit of his NRI children, then at that point of time, you will look at the fact that, okay, fine, today you put it in trust. I understand you want to put it in a trust deed, maybe in the future, maybe on a conditional basis, whatever it may be. Today, if I had to give that benefit to the children, whether as a settler could have done so, if not, then it means that that may not be clearly allowed under FEMA without a prior approval in place. If yes, if the provision is allowed, if there is a limit and those limits are met, or if there is a transaction which is allowed otherwise under FEMA, then the transaction may be all right. Otherwise, please go ahead and obtain an approval, or otherwise avoid such a transaction. And why do we say this? We say this because it is a very, very clear principle of RBI that what cannot be done directly cannot be done indirectly. By juxtaposing a trust in between a settlor and a beneficiary, so as to avail of certain more benefits than what is otherwise allowed to the settlor or the beneficiary, means that is something which is not allowed under FEMA. No, I have settled in trust. It's not to the beneficiaries right now. Later on, the beneficiaries will get, and once settled, therefore beneficiaries will tomorrow have their own kind of benefits to qua the trust. No, that does not work. as we already discussed, trust is not defined as a person under Fema. The only ways it has been allowed as a practice is as far as investment trusts are concerned, AIFs and the likes. Otherwise, you cannot do something which, say, for example, you cannot do directly. And I will give certain examples as we go ahead. You cannot say that, no, let me put in a trust and then try to do that. No, it is not allowed. So this is the sum and substance I would put it that a query was private trust, which has a cross-border angle. Please look at it that no, what if the trust was not there? What could have happened? And more than that now happens is that even after considering that, if you have certain issues which now are brought in by the uniqueness of the trust, which is the trustee or the foreign assets or the location of the trust, all those are added elements which can bring in more Fema issues. So then let us look at a broad structure. We already know what are the main elements of a trust: the settlor, the assets, and the beneficiaries. So keeping these three in mind, right now for a moment, for the few more slides right now, I'm not considering the issues related to the trustee, and that I will cover separately when I go forward. Right now, let us look at only that if there is a resident settlor, he has his Indian assets and Indian assets in which he has a beneficiary. Sorry, 1 second. I'll just see if I can get hold of a pointer. So resident settlor who has Indian assets, resident settlor who is settling Indian assets in for the benefit of a resident beneficiary, which means that all three elements are within India, then Fema does not apply. However, if a resident settlor wants to settle his Indian assets for the benefit of a non-resident beneficiary, cross-border angle comes in by way of a non-resident beneficiary and Fema applies. Then you look at a resident settlor who has foreign assets, which are obviously, as I already discussed with you, legally permissible, allowed foreign assets. Then you have a resident beneficiary. Again, because the assets are foreign, therefore Fema applies. And therefore, that doesn't matter whether the beneficiary is a resident or a non-resident. Fema will apply irrespective because the assets itself are a foreign assets. In which case, in certain cases where it is under LRS, I will come to and deal with it in a specific case study. Now let's look at a non-resident. Non-resident settlor who has foreign assets which are meant for a non-resident beneficiary, then Fema does not apply. Clear-cut distinction because there is no Indian element or no cross-border angle in this case. However, in a case where there are foreign assets but a resident beneficiary, then Fema applies again because the resident beneficiary brings in the cross-border angle. When you are non-resident settlor with Indian assets, but a resident beneficiary or a non-resident beneficiary, again, because a non-resident settlor is settling Indian assets, that itself brings in the cross-border angle, and the Fema will apply whether the beneficiary is a resident or a non-resident. I hope I have been clear here. Therefore, in couple of cases, you will have that Fema does not apply when everything is not crossing any borders. As far as this kind of a case, resident settlor with Indian assets and resident beneficiary, Fema will not apply. Similar mirror image of a non-resident settlor with foreign assets and a non-resident beneficiary, again Fema will not apply. In all other cases, Fema will apply. So let us now go into certain legal issues, and the first and foremost of those. Okay, is there any questions which I should take up right now? Or should I go ahead?
As of now, no questions, sir.
For going ahead, and please and I'll take them up.
Yeah, sure,
Okay,
sure.
fine, no problem. So let us go into the legal issues. The first and foremost issue that one needs to look at is that is trust a person under Fema? As we earlier discussed, it is not defined. Section 2U, which defines the person under trust under Fema, also does not cover trust. And therefore, it becomes as an arrangement between the settlor and the trustees, with the beneficiaries having an interest. But trustee is a legal owner, and therefore we come into place where is a trust residential status, which is a technically a gray area. Trust, can it have a residential status? Does the trustee's residential status count? Can the trustee itself be a resident or a non-resident under a cross-border angle? These are the issues which I would like to discuss now. Now, when you look at private trust, we have discussed there are various elements, but in which way the impact of Fema will happen? So, qua the settlers, beneficiaries, and trustees, we will have the issue of their residential status. As we already discussed in those charts, if those residential status has a cross-border angle, FEMA will come into play. However, not only that, their personal status also counts. Are they a company? Is it a firm? Individuals? We came across was where Indian trust was giving the benefit to a foreign trust. That foreign trust had the beneficiaries were individuals, and that led to complications because at the time of distribution, you are distributing not to the NRI concerned, but to a trust again, which was based outside India. So there can be then certain complications on account of that. Why citizenship important? Citizenship is important because NRIs and OCI card holders hold certain benefits which are not covered under FEMA for non-residents or foreigners, if we go to say. And therefore, certain come up if the beneficiaries are not, say all of them are not NRIs or OCI card holders, in which case again you may have to roll back. So that also I will take you through a case study where you will come across that issue. Then comes the trust fund, the trust assets. Where are they located is the first and foremost issue which comes across FEMA. But beyond that also there's a type of the asset. What is the type of asset which is held under the trust? Are those assets which can be held, or are they assets which cannot be held? Under a cross-border situation, if FEMA applies, there may be some instances where assets cannot be held. Again, I will take you through those certain issues or examples. And then finally, whether those assets are held under a repatriable or a non-repatriable route. And finally, we have the type of the trust. Is it a specific or discretionary? And I will explain how that probably may not matter much as far as FEMA is concerned. You may have very much a big issue as far as tax is concerned, but may not be as far as FEMA is concerned. Because FEMA looks through all these kind of issues. They go simplicity or they look at the transaction which is involved. Then you have the jurisdiction, where exactly is the trust under jurisdiction it is. Beneficiaries' rights. Are they simplicity or straightforward rights? Are they conditional rights? That is where also becomes an important part to play for FEMA. As I already mentioned to you, you will look FEMA qua the transactions which are involved. And therefore, what are the transactions when we look at a private trust? First and foremost is the settlement. Is it happening through the transfer during a lifetime, or is it happening on death through the will? Can have its own differences. I will explain those. What happens to the use of the assets? When the assets are settled, how can the assets be used? Can incomes be earned thereon? It may not be possible in each and every case. What happens about the distribution of the income? It again is a transaction. Can the income be distributed? Are there any limits to such distributions? And then finally comes that on the dissolution of the trust, or for that matter, the trust is ongoing, but they've decided to distribute certain trust property. Is it happening during the lifetime or on dissolution? So these are the kind of factors where the transactions may itself lead to FEMA issues, and how they are done, it becomes a very important part of the whole implications of FEMA. Already discussed, trust as entity is considered only for this following situations of for FBCI,
Mr. Rutvik,
for
one
FI
question,
investment by
one
pension
question.
trust. Yes.
Mr. Rutvik, one question regarding in case
Yeah,
of
please.
non-resident settler having
Yes.
a non-resident settler and non-resident assets, in fact, foreign assets of basically equity, shares, and mutual funds, all those things. Resident
Correct.
beneficiaries, how the FEMA applies here?
I will take you through a case study. I'm actually going to take you through that. So no problem.
Okay, fine,
I'll deal
fine.
with these. There are issues to it, and therefore we'll deal through that.
Okay, thank you.
Let me go ahead with that. So case study. Case study 1 is a resident Indian settler, non-resident beneficiaries. So what Mr. RI wants to do, he wants to settle immovable property. He wants to settle a bank balance, and he wants to settle agricultural plot of land and certain investments in an Indian trust. In which case, the beneficiaries are going to be non-residents and NRIs or OCI card holders. Please bear in mind distinction between non-residents and NRIs. Non-residents meaning those who are non-NRIs, those who are foreigners. What are the implications? When it comes to a resident Indian who wants to settle the property and funds in a trust, the FEMA rules will apply for what applies in by way of a gift, because in a way, when the settlement is being made, it is nothing but a gift. Again, as I mentioned to you, let us remove the trust from the concept for a minute. What is then happening? The sector is gifting non-resident beneficiaries, is gifting agricultural property to the non-resident beneficiaries, is gifting investments to the non-resident beneficiaries. which means you have to look at FEMA laws which are applicable to gifting transaction by a resident Indian. We all know that is possible under the LRS. But gift to a non-resident is only up to the LRS limit. The LRS limit at present is 2.5 lakh USD per financial year. That is the limit which will be applicable as far as even settlement goes to a trust. Gift is allowed only in rupees only to relatives, and those also defined as per the Companies Act in their own NRO account. Other than that, they do not allow gifts. Gift under LRS has to be in money, and there are certain compliances which are required for LRS. You can gift shares, but only up to 5 is a cumulative of $50,000 in a year. And on settlement, above rules generally cannot be complied with. Because what we are trying to do here, we are trying to do is that we are trying to settle it into a trust, which tantamounts to a gift to the beneficiaries, but which doesn't get remitted out of India, which doesn't get remitted into the NRO account of the NRI beneficiary. In which case, you have to first and foremost go for an approval from RBI and seek an approval that whether this can be done or not. In which case, you can also go and seek an approval that in which case, in certain cases, you may have that your assets are crossing the limits of $2.5 lakh, 2.5 lakh USD, and therefore you have to seek an approval if you want for a higher limit. Whether they give or not is a question mark. But at the end of the day, going ahead and settling something into the trust for benefit of a non-resident beneficiary without taking this approval will tantamount to that you have violated FEMA, because the gift provisions are only qua LRS and nowhere else. This is where we had, a chance to get an RBI view, and there was an RBI view. In fact, as I mentioned to you that, there have been instances where there have been probably some egregious statements made by RBI. And in this connection, they have written that, they probably feel that there is no permission required from RBI in such kind of a situation. However, that the trust should not assets which cannot be NRI or a foreign national or PIO. It seems to suggest that settlement of the LRS limit is all right, and in fact no approval is required, no limit is required. Foreigners can also be beneficiaries. Only restriction is on investment by the trust and no other conditions. Therefore, can somebody say that no, can I settle 100 crores worth of assets into the trust for benefit of a non-resident beneficiary? It cannot be. In our view, this was an incorrect view, and when we further went ahead and sought a clarification from RBI, the approval came with these conditions. The conditions were clear that a non-resident beneficiary should not undertake any transaction such as acquire, transfer, or repatriate any asset or sale proceeds through the trust, which he or she is otherwise not able to. Any remittance outside of India of sale proceeds or even the income of the trust assets during the lifetime of the settlors shall be within the LRS limits. On demise, the trust shall be distributed to the non-residents as per the terms of the trust deed, but remittances would again be subject to the FEMA regulations. This is in sum and substance what is an approval. We have sum and substance what is allowed under RBI's mandate by saying that during the lifetime of the settlor, what could the settlor have done? He could have only given a gift of $2.5 lakh, and therefore it will be limited to $2.5 lakh as far as the trust is also concerned. So what are the implications we are looking at for the NRI beneficiaries? One, on NR obtaining the beneficial rights in the property, beneficiaries get the beneficial right in assets other than through permitted modes, and therefore again FEMA approval may be necessary. As I already mentioned, settlement itself FEMA approval will be necessary. Non-residents cannot have a beneficial right in the agriculture property. Foreigners are not allowed to hold an agriculture property, so they would not be able to get it even through a trust. NRIs can hold agricultural property but cannot conduct agricultural activities. They cannot even be outsourced. As far as that agricultural land is concerned, it is allowed to be only no activity is allowed. That itself is also under a gray area. There have been several issues where even if FEMA may be silent or may not have said something, when you go to for registration of the sale deed or something, there itself you will have an issue. Non-resident beneficiaries cannot even get the distributed income on the assets beyond the LRS limit. Very, very important observation to be made here. Let us take an example, that is settlor wanted to say gift certain funds to a non-resident Indian beneficiary. Okay, so what happens in that case? The settlor would have said that okay, I am keeping certain funds in account and those belonging to you. As we discussed, that the rupee gift can be made, but to an NRO relative, to a relative to its NRO account. if there was any income earned on that gift, the NRI could have very well taken it out of India under the current account regulations, being that current account transactions do not prohibit any remittance out of India, and there is no limit also. Therefore, an NRI could have repatriated back into his own home jurisdiction any amount which has been earned as an income on that investment or that fund. But if that same asset is now kept through a trust, then is that once it is settled into a trust, there will be no way any further amount allowed to be remitted out of India beyond the limit which was applicable to the settlor. So what was the limit applicable to the settlor? $2.5 lakh under LRS. And that is the limit which will be allowed even for the trust when it goes to distribute, whether it be assets or income. It does not matter, the $2.5 lakh limit will apply. Which in this case means that the NRI's own $1 million scheme, there is a provision under the Fema whereby an NRI can withdraw up to $1 million or can repatriate up to $1 million out of India on an annual basis, which is by far a very, very big relaxation which is available, and beyond which also there is no other available limit also. And therefore, when you come to a Fema provision, which under Fema, if you're bringing in a trust in between, bear in mind the limit of repatriability will be restricted to that which was there of the settlor, because you are not considering the trust in between. What would have happened? You would have had a settlor who has gifted it to the NRI. What could a settlor would have only up to the last, not beyond that? Which again brings us to the case where what cannot be done directly cannot be done indirectly. We had learned of a structure where somebody had taken an approval or gone for an approval where they wanted that in the trust they would settle a huge amount. And then they said once settled, the NRIs who can avail of the $1 million scheme. So if there are 3 beneficiaries NRIs, then they can repatriate up to $3 million out of the trust. RBI just straight away rejected the application is what we have learned. The reason being that the limit will apply qua the settlor and not qua the beneficiaries. So please bear in mind that to do that for those assets only where you really need them to put them under trust. Otherwise, Indian assets may directly go to a NRI beneficiary, which may have better repatriability rather than going through a trust. Obviously, you have succession planning in mind, and you need to have some conditional succession done. Then yes, by far you may have to go for a trust, but otherwise a direct bequest to NRI beneficiary may be simpler. A non-resident beneficiary was a foreigner or somebody who is an OCI but has not held an OCI card, because bear in mind under Fema, it is not just the status has to be of an OCI, the person has to hold an OCI card. It has to be an OCI card holder to be equated with an NRI in most of the cases. In which case, if that person is not so, then again, it will become an issue. When you do go for an approval to RBI, they will look into all those aspects. They will look into who are the beneficiaries, are they NRIs? If not NRI, are they OCI card holders? And at that stage, if you say that no, they are not an OCI card holder and they are foreigners, then the approval will be limited. Foreigner can hold and not otherwise. And we all know that a foreigner through bequest or through transfer by way of gift to a foreigner is largely impossible, or rather there is a very, very low amount of things which can be done. And therefore, you are back to square one. So please bear in mind to see that what is the status of the beneficiaries also. Let us look at the other case study where a resident Indian settlor, which has both resident and non-resident beneficiaries, but there are foreign assets. And how there are foreign assets? The foreign assets are that resident Indian wants to settle his foreign property, foreign bank balance, foreign investment, which he has obtained. So now what will happen is that a resident Indian has remitted funds up to LRS limit every year. And out of that, whatever assets he has got, he wants to now settle it into a foreign trust. Ideally speaking, in our view, RBI resident Indian can settle those foreign assets bought through LRS into a foreign trust. The reason only being that once a fund or once an investment, once a remittance has been made under LRS, what is acquired through that LRS funds do not come into purview of Fema going forward. You can always say that, yes, I want to gift away those LRS funds to my children outside India. Yes, you can do so. You want to gift it into a trust? Yes, you can do so. Therefore, Fema issues may not come into play where LRS assets are held. But LRS gift to the resident is not permitted. It is very, very clearly specified. They have in fact written a very clear provision under the LRS directions to say that gift by one resident to another resident through LRS is strictly prohibited. So you cannot have a case where, say, Mr. A will put his funds under LRS. He has a foreign bank account in which those funds are lying, and tomorrow he cannot say that no, I want to give them to Mr. B, his son. No, Mr. A cannot gift such property to his son. He has to bring them back to India and then gift it, all right. But under LRS, they cannot do so. And therefore, it means that any trust which has Indian beneficiaries in this kind of a case cannot be formed at all. Even going through RBI, in our view, RBI may not give an approval for this kind of a structure. You may very well have to keep a separate trust for a Indian beneficiary which deals with Indian assets. But if there are foreign assets in the LRS, they cannot be resident Indian beneficiaries again for such kind of a trust. Even if it is a discretionary trust, it does not matter. Please bear in mind, under Fema, discretionary trust or a specific trust, there is not much of a difference. Discretionary trust does not make any much difference. You are looking at a transaction which is being consummated, and that transaction, if it is not allowed under Fema, RBI's approval will also probably become a non-starter. Now, what are the implications as far as the non-resident beneficiaries are concerned? They are getting a beneficial right in foreign assets. Again, there are no issues under Fema because you don't have to go under Fema. There is totally outside India. Both the elements are outside India. The transaction which leads to a beneficial right for the non-resident is qua foreign assets. Again, no Fema comes into play. Get the distribution of assets. Yes, there are no Fema issues. This is where there is a leeway as compared to the earlier situation or the case study 1, where we had a limit for distribution of income and assets up to the LRS limit because those are Indian assets. Today, these are foreign assets, and therefore there will be no limits as far as even distribution of income or assets goes. What happens to the resident beneficiaries? Even if it would be, say, for example, even allowed, which I already mentioned to you, very, very serious doubts on that being allowed. In any case, they are resident beneficiaries. They have to get back the asset back into India. We already saw sections 4 and 8. RBI will not give anyways any approval to hold them outside India. They will have to get them back into India. I hope I have been clear till here. I believe the query was with relation to an NR settlor, and therefore I am now coming to case study 3, where you have a non-resident settlor who wants to settle Indian property, Indian balance into an Indian trust. So we have a settlor who is outside India, trust is in India. He wants to settle his assets which are already held by him in India into a trust for the benefit of Indian beneficiaries or resident beneficiaries. I should be using the correct terminology for the resident beneficiaries. So can a non-resident transfer his Indian assets to the Indian trust? Yes, he can do so because those Indian assets will go into a trust which is within India. Can the resident beneficiaries get beneficial rights in the Indian assets? To our view, there is no issue under Fema because again, this is qua within India. There should be no issue. I'm sorry, here just to take an iteration which I have not covered in this case study here, but if say, let us say that there are non-resident beneficiaries to this. What will happen is that the non-resident beneficiaries are getting these assets of within India. Again, as I mentioned to you clearly, that who are those non-residents? Are those non-residents NRIs or OCIs, and are they able to hold those assets if the settlor would have directly given them to or gifted them to that NRI or OCI? If so, they will be allowed to be held through the trust also. However, if, for example, it turns out that there is a foreigner and that foreigner is not able to hold, for example, say in a case like immovable property, and NRI may not be able to gift away the immovable property to a complete foreigner, in which case then you are going back to square one. Even through the trust, it will not be allowed. You will have to go to RBI anyways for approval in this case, but RBI's approval may not be given as far as this issue is concerned of a immovable property. They will just say that no, the approval may get rejected. The application may get rejected. So please bear in mind that when you have a cross structure, whatever is of today is what will be allowed as far as trust is also concerned. Then let us look at case study 4, a non-resident settlor with Indian beneficiaries but with foreign assets. And if I'm not wrong, probably the query was referring to that. So now what is happening is here is that a non-resident settlor is settling foreign property in the bank balance, foreign property, bank balance and investments in a foreign trust. the beneficiaries will be resident Indians. Obviously, when we look at it, the cross-border situation, it is a non-resident who is transferring his foreign assets to a foreign trust, no issues under Fema. But when it comes to resident Indian beneficiaries, they need to bring those assets and funds back to India. Section 8 says that you cannot have any liability or any receivable lying outside India. You need to immediately bring it back into India, which means that if you really want to hold on to those assets, you need to go to RBI and seek an approval. You need to go to them and tell them that please allow us to maintain these assets outside India. I have held it in the trust. I would like to keep them outside India. To our bearing, it will depend on what the RBI says. RBI may or may not give approval in such a case. It depends on situation to situation. There are many factors which come into play. But please bear in mind that if there are incomes which are distributed from such trust, they need to be brought back to India. We have serious doubts that RBI would allow even those to be held outside India. Again, as I already discussed, there will be no difference on account of that trust being a discretionary trust, except what happens if there is a condition attached to the trust deed. Just as an example, the settlor has settled some assets or some investments in the trust deed. Those assets will not go to the beneficiary until he or she attains the age of 35 years. Just as an example. Now what happens? Now the beneficiary has no right to get it back into India, and therefore they may get stuck. However, RBI, whether they will accept that view or not, that because of that condition you cannot get it back into India, is a untested theory. We do not know what will happen. There is something which we will have to go to RBI and explain them that this is what the trust deed says. It is not in your hands, and therefore whether they can be allowed to be retained outside India until that condition is met, and thereafter get it back into India. These are the major popular arrangements as far as non-resident or cross-border private trusts are concerned. What I would now like to bring out is certain differences between certain very important transactions. One is between the bequest and settlement. So where inheritance by a trust happens, inheritance happens through by way of a trust. What I have discussed till now is private trust, where during the lifetime of the settlor, he gifts away those funds to a trust, and therefore the trust then is holding those assets in benefit of the beneficiaries. In that cases, as we discussed, the transaction is of a gift transaction as far as resident is concerned, and even a non-resident is concerned. Those the provisions will apply. But when it comes to inheritance, say what happens if a trust is created by way of a will? In our view, inheritance is obviously permitted through a will. There is no objection. However, RBI may take a view that your transaction of holding it or acquisition of holding it by way of inheritance, which should have come directly but is now in the hands of a trust or under a trust arrangement, in that case an RBI approval is ideally advisable. The reason is that because there is no clear-cut provision which allows you to hold your inherited assets, say for example a resident beneficiary holding just because it is out of inheritance doesn't mean that it will be allowed to be held outside India in the name of a trust. They will have to seek an RBI approval in this case. And as if they are in line with Fema provisions, if the inheritance could have anyways come, probably there would be no issues and their approval should be available. On bequest, as compared to when way of a settlement, what is the difference? That on bequest, there is no restriction at the time of transfer of trust to will to a resident or a non-resident. There is no restriction. However, when you go to settlement option, then for a resident,
Rutvik.
Yes.
Rutvik,
Yeah.
one question regarding that non-resident settler and non-resident asset. Indian beneficiaries,
Yes.
you said,
Yes.
so they may have to bring back those assets. In case
Right.
discretionary trust and having certain conditions of a certain number of years and all. In such
Right.
situation, is the beneficiary, Indian beneficiary, needs to inform those things to the RBI?
Yes, as we all discussed right now, there is a
beneficiary
cross-border
of foreign
situation
trust?
happening. There is a beneficiary who is happening. Yeah. Sorry, can you hear me?
Yeah.
Yeah. So you see what happens in these cases, all these cases, as I already discussed, these are the cross-border issues, in which cases anyways, our view is clearly that an RBI approval will be required. There is no way that an RBI approval will not be required. As I explained earlier, a beneficiary creates a beneficial right in lieu of or for assets which are situated outside India. That is a capital account transaction which has not been permitted specifically under Fema provisions. And therefore, automatically that means that the person has to go and seek an RBI approval. And at that stage, whether he needs to hold them outside India, whether there is a condition attached to those distributions or dissolution, etc., all that will be a matter of debate. At the end of the day, whether RBI allows or not is something which is circumstantial or something which will have to be depending on the facts of the case. However, RBI approval is a must. It's not just about informing. It is actually applying for an approval to have through the trust for a beneficiary who holds a beneficial right in lieu of foreign assets. Am I clear here? Or
yeah, I got it. Thank you.
So whether it be case study 4, 3, 2 or 1, please bear in mind, in all these cases, in our view, an RBI approval is required. Whether it be a discretionary or a specific trust would not make a difference. Let me take that first. What does a specific trust do? The beneficiary's rights are known and crystallized, which means under Section 8, the specific trust, you need to bring the assets back to India. Indian Trust Act, beneficiaries can in fact call on the trustees for the distribution of assets. So if there is an Indian trust, which by far a non-resident would generally not create, but if you have a case where there is an Indian trust and, for example, there are Indian assets in those trusts for resident beneficiaries, in which case, if it is a specific trust, as we have discussed earlier, then to that extent, Fema does not apply. Therefore, on a cross-border angle, to have an Indian trust, generally speaking, does not. However, if trust which is governed by the Indian Trust Act, there is a right to the beneficiaries to call for the dissolution of the trust because they know what their benefit is. And if they can do so and there are no conditions under the trust deed, they can straight away call for the dissolution of the trust, and the trust assets have to be brought back into India because of operation of Section 8 of it.
Then
However,
just a minute, just for a clarification, in such situation, forming that kind of private trust is not at all idea at all. No?
Impractical, honestly speaking. It's impractical, not advisable only. Why do that? But at the same time, the trust law, if it is of a foreign country, the trust is formed in a foreign jurisdiction, then what is its trust law? What it is forming, how it is formed, will all have to be looked at. In any case, at the approval stage, all of those details will have to be looked at. Again, here, what happens if the trust deed is conditional, as I already mentioned, age, or say, for example, there is a life interest which is given. In all those kind of cases, you may have to look at the trust deed and then go ahead to RBI and mention that these are the trust conditions. You cannot pretty much do anything because of those. RBI takes into that consideration and then allows it. Probably you may have to take a call depending on what the facts of the case are. However, if it is used as a planning mechanism, generally speaking, RBI will just reject the application, and therefore you may end up being in a fix. Because there is a foreign law which now operates as far as the trust is concerned, and the RBI has mandated that you have to bring back those assets into India. Please bear in mind that some assets you cannot bring back. So like immovable property, you will have to sell off and bring the proceeds back into India. In which case you will have to do so. There is no leeway as far as Fema is concerned. But in genuine cases where you can probably put up that, yes, this is the case and this is how it wants, especially where you have cases where, the succession cannot happen to certain children who are may not be able, or say they are minor children, or they are those with mental incapacities. In those kind of cases, there are genuineness why those assets cannot be transferred to the resident beneficiaries, in which case then you will have to put up that case of genuinity to the RBI, and therefore approval will be accorded in those terms. Again, discretionary, what is the major difference? The difference is that the beneficiary's rights are known, but they're indeterminate. See, beneficiary does know that he has a right in the trust assets. Well, what he doesn't know is the fact that he does not have he does not know the share of his trust property. What share will he get at the end of the day? Again, RBI approval is still needed. It is not so that just because it is a discretionary trust that you do not need an RBI approval. RBI approval would still be required, is our view. There are differing views on this topic. To be honest with you, there are people who have taken a view that discretionary trust, you do not need an RBI approval. In our view, Fema does not take into account whether this is a specific or a discretionary trust. They are only looking at what the transaction is, irrespective or holds the trust structure in between.
So in case of that transaction, if something which is not allowed is being planned through a discretionary trust, then they will disallow that, or they will not give the proper approval for that kind of a trust structure. I hope I have been clear here. Going back to the differences between the bequest and settlement, as I was mentioning, that for a resident, the restriction on transfer to trust there is by way of, as we already did, this limit applies. They cannot bequest or they cannot settle more assets than the LRS limit. But when it comes to bequest, the wealth which has to be bequeathed to the non-resident beneficiaries at the time of death, then obviously all the wealth will go to the non-resident beneficiaries. There will be no limit applicable. The limit which will applicable will happen by way of distribution. So let us look at that. That for resident beneficiaries to hold assets which are outside India, if the inheritance is from a non-resident, and I'm looking at bequest here as co-settlement. So what happens in case of a bequest? Inheritance is from a non-resident, then inherited funds have to be brought back into India within 180 days. However, immovable properties and other assets which are lying outside India, when they are from a non-resident, you may have to take an RBI approval. Only in case of a returning Indian. And what do we mean? We mean by a returning Indian? A returning Indian means a person who was a non-resident but who has returned back to India and settled in India for good. Therefore, he has become a resident Indian, an earlier Indian. These are colloquially called as a returning Indian. There is a series of circulars of 1992 by way of which under Fera itself, quite a few relaxations were provided to returning Indians to let them hold their assets outside India, to let them they can pretty much do what they want with those assets outside India, because that was a relief which was given to returning Indians. That relief has continued by way of section 6 subsection 4 of Fema, where it says that yes, you can continue to hold those assets outside India in case of a returning Indian. In those cases, inheritance is slightly more relaxed than what it would be in case of just a non-resident. A strange system for a non-resident, there are more restrictions than for a returning Indian, but that is the case. In which case, inheritance from a returning Indian, foreign property which can be acquired while he was a non-resident is permitted to be held outside India. Gift of such property is also permitted. Subsequent gift can be to a relative. Is allowed. This is the only place where you require an RBI approval. You can also have shares outside India which can be held outside India. Again, for the sale, you may need an RBI approval, but you can at least hold assets if they are from a returning Indian. If they are from a non-resident, as I already discussed, you may have to seek an RBI approval, and for funds, you may have to bring them back to India. We already discussed about specific and discretionary trust. The last element and one of the again important elements of a trust is the trustee of a trust. The trustee of a trust is the legal owner. He is not a beneficial owner, but obligation leads him to become a legal owner. And legal owner, in that case, a RBI approval will be required whenever there is a cross-border situation again. Say a resident trustee, but only of a foreign trust, or a trust which is holding foreign assets. A rarity, but let us say that it's a foreign trust, then itself a resident trustee, when he holds a foreign trust, can he become the legal owner as per Fema provisions? If he cannot, then again an RBI approval will be required. Let us now look at the other way now. Non-resident trust for trust, and that can happen, right? So for example, I myself want to keep assets under trust for my children, but with a non-resident trustee. Say for example, I say my brother will become my brother who is in USA will become the non-resident trustee for the trust in India. Again, that becomes a cross-border situation. The problem is not as much as Fema, because an NRI could probably hold certain assets in the legal name, at least, though it is for the benefit of the beneficiaries, it can probably hold. But the problem also sometimes happens when you go to banks, when you go to regulatory or stamping authorities, when they want to register those assets into the name of the trustee, is when you may have an issue, when they may ask for where is the approval under Fema in certain cases. Again, in that kind of a case, you may have to go for an RBI approval. Very most important point is that an NRI or OC under trustee can activities or hold assets under trust which non-resident trustees cannot. Non-resident meaning a non-NRI or a non-OCA card holder. What I'm trying to say here is, say for example, there is an leeway which is given to an NRI to do certain activities under Fema, and that such an NRI becomes a trustee of the state trust. In that case, he may be allowed to continue to do those activities because they are anyways allowed for an NRI to do. Please bear in mind, honestly speaking, they are only legal owners, but all actions which are being done in their name as a legal owner, even though they are done for the benefit of the beneficiaries. And therefore, in a way, RBI is saying that Fema will apply. You can try to say that no, why does it apply? Because trustee is only acting on the benefit of the beneficiaries. But no, especially in a discretionary trust, there may be then cases where they will hook onto the trustee and look at the trustee how it is to be determined is what they will look at. There have been cases where applications have been rejected because the trustee was somebody who was non-resident and was there is a case of an application which was made to DPIIT, now DPIIT, at that time the DIPP, for having a fund where the investments would have been made into a defense sector. Everything else was within India. The assets were within India, the beneficiaries were within India, all those was fine. But the trustee was a non-resident, and that itself became the cause for rejection of the application. So please bear in mind that what RBI will look at is that whether that particular trustee as a legal owner could have done or not that activity, and in which case if that is not allowed, then again that may become a reason for rejection of the application. This by far covers what I wanted to cover as far as the overview of Fema implications as far as a private trust is concerned. Last but not the least, compliance with Fema is a must. Sincere request that Fema, Fema is no longer to be taken lightly. There have been cases where industrialists have come to us and said that let us violate and then pay the compounding fee. No, please do not dare to do so. It is now technically draconian than FERA also, because now there are seizure of assets within India, which are provisions have come in Finance Act 2000. And violations can lead to penalty and even prosecution where the intention is malafide. And once it goes into the books of the Enforcement Directorate, it's something which doesn't get completed for ages and ages, or maybe never so. Also, please bear in mind that if there are violations, then RBI can ask to cease and desist, or even to wind up those investments if they are not in line with Fema. Certain times, even the whole of businesses. So please bear in mind that something which is otherwise not allowed under Fema can anyways not be done through a trust. However, if there is something which you really need as far as extension of limits or extension of certain holding periods, all those are things which you can go under Fema and take an approval from RBI. That is where the only discretion is allowed. You go for approval, otherwise your suo motu discretion, there is none. I'll go into certain practical issues for as far as private trust is concerned. These were legal issues, but let me go into some practical issues. You may look at it from a jurisdictional analysis, and generally what we tend to do is that we jump to under private trusts. Very, very important issues, but please bear in mind Fema is also equally important. So when you are looking for a jurisdiction where the private trust has to be housed, don't just look at it from a tax perspective, you also look at it from a non-tax perspective. Check those inheritance laws in those countries. What are the estate duties which are applicable? What are the execution processes when they actually try to execute the trust? What are the hidden costs? Sometimes you have seen that, once the trust is settled, the trustees eat away sometimes even the huge portion of the wealth just by charging fees or creating. In one case, for a client, we are surprised to see where under the trust they had created almost not less than 40 to 50 entities, just because every entity was giving them a fee. So, these are the issues which one may not realize, but one must be aware of. What is the judicial strength? There are countries where the foreign laws give more benefit or more strength to the trustees rather than the beneficiaries. And in which case, if there is, then you will tend to all the trust assets on favor of the trustees. And they may go into some reserves somewhere. Tax havens are under scanner for now a long time. And if you have something where you trust in, say, for example, a Cayman Islands, or say, for example, an UAE kind of where there is a tax haven, please be aware there will be more number of queries than you can foresee. They will probably presume that there is some tax saving, and even RBI may go into the picture of whether this approval itself is acceptable or not. Even though they have nothing to do with tax, but the tag which comes along with those tax havens will carry and will have a reputational risk. Foreign laws will have to be adhered to, including FATCA and CRS. Almost everywhere now, please be aware that under a trust structure, may it be settlor, may it be the trustees, may it be the beneficiaries, all details are given under those FATCA and CRS forms. Your passport, if it is there, then that will be what will be shared, and those details will come automatically into India. There have been substance requirements post the BEPS and MLI impact as far as tax is concerned, but those are minimal. At the end of the day, certain times what will happen is that by way of those substance your costly exercise, and therefore considering all the gamut of issues, you can also sit back and consider whether the trust structure is the most viable or is there any other way of succession planning. And if it's not an option, then yes, you may have to go through, but go through in such a manner that you do not face queries, or the client's heirs do not face the queries, and they do not think that, okay, now we are stuck and we have to go and beat around and go to RBI again and again. So please bear in mind that these are certain practical issues which one must bear in mind. There are several tax issues. Mr. Rashmin Sanghvi is going to take those issues, so I'm not deliberating them in detail here. If there are any questions, please do let me know so that I can now take them out. Thank you.
Yeah, as of now, I think no other question. There are 2-3 questions. I think sir has already answered, and he is going to answer all those connected to income tax issues and other issues.
Income
issues, no other question, I believe. There is one chat box that is also connected to sir only. I think sir can continue. You want a break, sir? Or you can
No, we can continue. No problem.
Yeah, we'll continue, sir.
Yeah. Okay. Now, please allow me to share my presentation.
Yes.
Yeah, Suraj.
Okay.
Yes, sir. Please share.
Please, yeah.
Sorry, I'm not able to share my presentation. I don't know what is the problem.
Please open the file.
Suraj, you have the presentation of sirs?
No, sir.
Yeah, my presentation is, I have opened it on my computer, but
if you click on the share link,
Sir,
it
please
should
click
show
on the
up
share.
windows.
yeah, that is what I did.
So are there 4-6 windows which are now showing?
You can click on share screen, sir. It will take the desktop share. So
Yeah, share content. Now the file is there. I have selected the file. Now,
Double click on
huh?
Double click on it otherwise.
Okay.
Yeah, it is now coming.
Okay.
It is there.
Just you'll put on
Slideshow.
presentation mode.
Yeah. Okay. Good evening, friends. Thank you, Mr. Shetty, for inviting us for this presentation. It's our pleasure to share some of our thoughts on private trusts. I'm just making a small clarification that we will not be covering charitable trusts because that is a whole area, a separate branch of taxation. we will not cover. We'll cover only private trust or what is known as family trusts. Now, the Indian Trust Act, succession planning, all those things must have been covered on last Thursday. Sorry. I may briefly touch upon them whenever necessary, but otherwise my main presentation will be on taxation. And since taxation will be affected by the trust status, etc., where necessary, I may refer to other laws. Now, the tax provisions for a trust are very complicated. Let us say a chartered accountant, fresh chartered accountant, or an article student straight away starts reading the tax provisions. He will be completely confused. It will be difficult for him to understand why this provision is there or what is its correct interpretation. Now, why it has become so complicated? The reason is that we should understand trust is not an Indian concept. Our concept is HUF, Hindu family, and the family will take care of everybody. So why do you need a trust? Now, trust is a foreign concept. In India, earlier, very few people were using trust. Then somewhere around 1970s, trusts became popular as tax planning instrument. And then whole lot of people started using trust, AOP, HUF, and so many other entities for tax planning. Now, this is the reason why it has become very complicated. Because when taxpayers do tax planning, government comes out with an anti-avoidance provision, and that complicates the law. And if somebody straight away reads anti-avoidance provision, he will not even understand what is the provision. What kind of planning was done? So let us understand, actually, only when a person understands what was the planning being done, what is the anti-avoidance provision, then he will understand the provision. Now, what planning was being done in the 1970s and 80s, okay, it has completely changed today. In those times, the planning, certain kind of plannings were done. Those plannings are not at all important today. So if today a student or a fresh chartered accountant tries to read these provisions, in fact, I have seen writings by senior professionals who have not understood these provisions because they have ignored what was being planned in the year 70 or in the year 80, and they have not understood the provision of the law. So I will today try to explain the planning, the anti-avoidance provision, and then the correct interpretation of law. Now, what was being planned? Before that, I'll have to say, the next slide. See, in the year, today people do not know how lucky they are, because under income tax law, today the direct taxes are very, very comfortable, much better than what was the rate in the year 1973-74. This is the time when I was doing my articleship, and income tax rate was 97%. Just imagine if somebody earned more than 1 lakh rupees, then on every additional rupee, he had to pay off 97% to the income tax department. On top of it, there was a wealth tax of 8%. And even with this, the government assumed that somebody would be rich enough to pay estate duty. So there was an estate duty of 80%. So it was guaranteed that there will be no Indian who will be a rich person. Everything will be taken away by government of India. Now, these were a socialistic kind of rules where government did not want anybody to be rich. But people, of course, wanted to be rich. So what would they do? So they will do a lot of tax planning. Massive tax planning was the practice in those times. Now, let us assume that somebody in a family is earning, say, 10 lakhs of rupees. Now, all the 9 lakhs in excess of 1 lakh, it will almost go away to the income tax department. Then on his wealth, he will have to pay 8% wealth tax. Okay, so even balance 1 lakh will go away in income tax, in the wealth tax, and he will have to sell his assets for his day-to-day food expenses also. That was the position. So people created any number of entities. So if say father is earning 10 lakhs of rupees, he will transfer some income to wife, he will transfer income to his children. So let us say there are 5 family members, the income will be divided amongst 5 family members. Then every person gets a basic exemption limit, gets the lower slab rates up to 1 lakh. Under wealth tax also they would get basic exemptions, lower tax rates, and also chapter 6A deductions. Now all these benefits together will reduce his tax from almost 10 lakhs to let us say 5 lakhs. Now supposing somebody has an income of 1 crore of rupees, what do you do? Now there were people who were earning quite a lot of money. So then they started using HUFs, trusts, AOPs to create separate entities. Now let us say you create a trust. I will come into trust taxation little later, but every discretionary trust is a separate entity. So in those times, a trust created for my family members would again get a basic exemption, would get lower slab rates up to 1 lakh of rupees income. So there was a famous industrialist in Gujarat. They started settling trusts. Okay. Now say Mr. Sethi is a crorepati and he is settling trusts. Okay. Now he wants 1 trust each for an income of 1 lakh rupees. So he needs 100 trusts or more than 100 trusts also. So you don't have so many family members' names. So what do? So they started with river names from Ganga, Jamuna, they came up to Kaveri, they went to the tip of Kerala, and all the names of rivers were exhausted. Then they started combination of some other names. You can imagine the kind of planning which people were doing through trusts. Okay. So the idea in settling different trusts was primarily getting maximum tax benefit. Government came out with several kinds of anti-avoidance measures, meaning they prevented the tax planning. In the process, the whole law became extremely complicated. So when government passes an anti-avoidance provision, okay, it is referred to as specific anti-avoidance rule or SAR. Now there are separate categories of SAR. One is clubbing the income back in the hands of the transferor. Second is clubbing the income back in the hands of parents. And third is maximum marginal rate. So these three, I'm sorry. Yeah. So these were the 3 methods in which government has come out with several anti-avoidance provisions. These provisions we will look at in more details. Okay. Now my presentation is structured on these lines. Okay. I want to make the tax provisions very easy for everybody to understand. It is always my attempt that my article students must understand the provision. So if he understands and article student understands, it will be perfectly fine for chartered accountant. And that is my attempt here, explaining. And then at the end of the day, can we settle a trust today? And what kind of trust should be settled? This is what I will try to cover. Now, before going into the tax provision, I'm briefly touching upon what is a trust. So when a person called settlor transfers a specific property, which can be called trust fund, to another trusted person, whom we call trustee, to hold and manage the property for the benefit of others. Okay, I will now read the sentence again. When a person transfers a specific property to another trusted person to hold and manage for the benefit of others, and when the other person, meaning the trustee, accepts the obligation, then a trust is created. That obligation, acceptance of obligation, is called a trust. The confidence reposed by the settlor in the trustees is called a trust. So the trust is a relationship of trust among settlor, trustees and beneficiaries. Trust is neither a separate entity nor a legal entity nor a person. See, prima facie, individual is the natural person. Thereafter, a company is a separate legal entity because the law grants it a separate entity status. A limited liability company, a society, these are legal entities. As far as income tax is concerned, under section 2 subsection 31, HUF, partnership firm, AOP, they are deemed to be person. And once they are deemed to be a person, they can be taxed under the Income Tax Act. But for trust is not included under section 2 subsection 31 of the Income Tax Act. So trust is primarily not a person, and in fact the entire Income Tax Act does not even target a trust to be taxed. Now there is another aspect of a trust. A trust means separation of ownership, management and benefits. Now I want to explain this concept with an illustration. We all understand company. A company means the ownership and benefits are with the shareholder, but the management of business is with the directors. So ownership and management are separated. Okay. Now company and the company law are administered by the Registrar of Companies or the Ministry of Corporate Affairs. The company is essentially a commercial arrangement. In case of trust, the legal ownership and the management of the trust is with the trustees. The beneficiaries are beneficial owners and they get all the benefits. So here is a separation of ownership as well as management on one side and enjoyment of benefits on the other side. But trust is essentially a social or a family arrangement, and for such family arrangement there is no regulator. Just as we have a registrar of companies or we have SEBI, they regulate investment, they regulate corporate affairs. For private family trust, there is no regulator. Now, so okay, why do you settle a trust? In a trust, the owner of an asset, I'm giving an illustration where say father in the family makes a trust for his children. Okay. So the father transfers the assets to the trustee for the benefit of his children. Now, the best option is that the father continues to own the asset. Why should he transfer to somebody else? There is no reason, logical reason for him to transfer the assets and settle a trust. Okay. If at all he needs to transfer, he should transfer directly to his children. Again, why settle a trust? So, this I have explained by an illustration that let us say there is an aging father. We have a case right now where the father is aged 87 years. He has several children, but one child, of course, it is not a child, that lady is now aged 60 years, but even today she is mentally handicapped. Okay, so father is always worried about his children that in case father dies, he will be no more available to take care of that handicapped child. Who will take care of the child? Now, this is the situation where a trust is a necessity, because father, while he is alive, he will settle a trust. He will be one of the trustees. He will also appoint 2-3 other trustees, presumably 20 or 30 years younger than him. Now, so when the father dies, those other trustees will continue to hold the asset and they will look after the handicapped child. This is a very genuine requirement, genuine circumstance in which a trust would be bona fide, trust would be necessary. Who should be trustee? Ideally, the owner of the asset must continue to own himself. Now, many times the settlor himself becomes a trustee also. So that is fine. He will continue to have the control and management of the assets. Now, third party can be involved. I just gave an illustration only when the circumstances justify. Okay, now before going to taxation, I am also covering one concept, which is a unique concept applicable only in case of trusts, and that is a life tenant and a remainderment. Now, the life tenant means, say there is a person who has settled trust. Okay, the father settles a trust where he says his wife will have a life interest in the assets of the trust and his children will be the remaindermen. Now, this would mean that supposing the father dies, the wife will continue to enjoy all the property. She will live in the house. She will earn the interest and dividend income. She can spend the dividend income, but she cannot sell the property. She cannot sell away the securities. She cannot use the principal. She can only use the income. And when the wife dies, the children, their children will become the exclusive trustees of the trust, and then they will enjoy the principal as well as income. So this is a concept of life tenant and remainderment. There is a small little tax planning also possible, but essentially this is for genuine circumstances where the settlor wants to take care of more than one generation. So the present generation, the next generation. This is an illustration I have given here. And in case of life tenancy, in the earlier times when wealth tax was 8%, a lot of people settled trusts. Let us say there is a property worth 1 crore of rupees and it is settled into a trust. Then the life tenant can only enjoy the benefits of the property. So the value of life tenancy will be probably about 10 lakhs. The total valuation of remainderment's interest may be about, say, 50 lakhs. So total will come to 70 lakhs, which will be less than the market value of the asset. So on the balance, that is the shortfall of 30 lakhs, they would save wealth tax. Now, you imagine 8% when people were earning 10% as income on the principal. If 8% is going away in wealth tax, it means 80% of income would go in wealth tax on top of 97% of income into income tax. So every pie saved was very important, and that is why even life tenancy remainderment was used as a tax planning instrument. I'm taking another illustration or another aspect, because if any of the participants want to advise their clients to settle a trust, then what happens is sometimes the banker and other authorities ask for registration of a trust deed. But as we have seen, there is no regulator within India for trusts. Now, if there is no regulator, where do you register? It is impossible to register a trust deed. Since banks are asking for it, and so many other authorities also keep asking, with the wherever the trust has to get involved in any commercial transaction, the counterparty will ask for the registered trust deed, because they are not aware of the legal situation. That is why they are asking it. Otherwise, there is no business. Nobody should ask for a registered trust deed. So, but as a practical way out, there is a registrar of sub-assurances. He will register any document that you give to him. So it is just that when a sub-assurance registers a document, it is just an evidence that somebody signed a document and on such and such date. So he will then give make a seal on the document that it has been registered with sub-assurances registrar. That is all. Otherwise, that registrar is not a regulator of trust, and there is no other legal significance of that registered trust deed. But the banks accept it, so this may be a practical way out. One should notice that the moment you register your trust deed, it becomes an open document for anybody to investigate. So your private family matters will become public matters. There is also a confusion that whether trust is a contract, but as Rutvik has explained in the earlier session, trust is not a contract. It is not governed by Indian Contract Act. We have different kinds of contracts. Okay, Now, memorandum and articles of association is a contract. That contract is governed by Companies Act. Partnership deed is a contract governed by the Partnership Act. Other contracts are governed by Indian Contract Act. But a trust is covered under the Indian Trust Act. The rights and duties of the trustees, beneficiaries, and settlor all are governed under the Indian Trust Act. Okay, in case of foreign trust, of course, that jurisdiction laws would be applicable. But within India, a trust deed is not a contract. Okay, and in a contract without consideration is invalid. There must be a consideration. In a trust, there is no consideration. Prima facie, as per the Indian Trust Act, the trustees are not supposed to take remuneration also. In the trust deed, if they make a provision, if the settlor makes a provision that yes, the trustees can take remuneration, then they can take. It is similar to partnership deed, that there are certain provisions subject to the specific provisions in the partnership deed. So if the partners make a provision different from the Partnership Act, to a great extent it is permissible. Similarly, under the Indian Trust Act, if the settlor makes a certain different provision to pay remuneration to trustees, that is permitted. But otherwise, prima facie, there is no consideration why a trustee acts as a trustee, because this is a family affair, it is not a commercial affair. Now, this is a very stark distinction between a trust deed and a contract. So now we come to the issue that if trust is not a person, how does Government of India tax a trust? We always say that this trust has to pay X amount of tax, or the trust is taxed at a particular rate of tax. Frankly, Income Tax Act does not even target to tax a trust. The person who is taxed is a beneficiary. Okay, the trust as such is not an entity. Trust does not pay tax also. It is the beneficiary who ultimately suffers the tax. But in a trust, there may be several beneficiaries. So how does the income tax assessing officer make the assessment on several assessees? Okay, so as a practical administrative convenience, there is a machinery provided, and that the trustees will pay the tax. The income will be considered as the income of the trustees. They will pay up the tax, and ultimately, of course, the beneficiaries will suffer. So trustee is a representative assessee, and there are specific provisions made under the law for representative assessee. These are the provisions. Section 160, subsection 1, clauses 4 and 5. They are providing that is the provision to say that trustees are representative assessees. Then section 161(1) provides, and this is a very important provision, that trustees are liable in the like manner and to the same extent as beneficiaries. Now, friends, let us understand that this is now I have started specifically considering the income tax provisions applicable to private family trusts. And this is the first issue. Trustee is a representative assessee. He is not personally liable to tax. Trustee may be anybody, he may be individual, it may be a company, it may be an LLP, whatever. Who is liable to tax? Essentially beneficiaries. So trustees will pay tax in the like manner and to the same extent as beneficiaries. And let us say Mr. Patel is a trustee. Now Patel has an income of only 1 lakh rupees. But where he is trustee, the trust has income of 50 lakhs of rupees. Now that 50 lakhs of rupees will be taxed in the status of the beneficiaries. I will elaborate little more, but that 50 lakhs will not be added to Mr. Patel's personal income. As far as he is personally concerned, there will be a separate assessment order on himself as a personal. For trust, there will be a separate assessment order. So I'm explaining this matter issue of in the like manner and to the same extent. Income Tax Act will apply as if beneficiaries are being taxed. Now, let us say there are several beneficiaries. For illustration, we say there are 3 beneficiaries. Then the trust income will be divided amongst the 3 beneficiaries. There will be 3 separate computations made by the assessing officer of the trust. He will pass an order, and that order will be sent to the assessing officers of all the 3 beneficiaries. And the AO of the beneficiaries will add this trust income to the beneficiaries' other incomes. And then the gross total income will be then taxable in the hands of the beneficiary. Okay. Now, Mr. Sethi had asked me before the commencement of this session that in this computerized manner, computerized way of filing return and assessments and all that, how will this be practical? How will this be administered? Now, friends, we have all realized that the software which is now being used is deficient in many issues, many aspects, because when it was a personal assessment, a lot of adjustments could be made. Adjustments to fit with the situation could be made. In a software, you are bound by the software. So government will have to come out with some way of dealing with a trust and the beneficiary assessment. I personally don't look into this software aspect, so I'm not very much aware of how software will work out. But under the law, the legal position is that trust or trustee assessment order will be passed, with ultimately the trustee's income as far as the trust is concerned will be reduced to 0, and all the income will be apportioned to the beneficiaries who will pay tax in their personal assessment. That is the primary position. And let us, when we say in the like manner and to the same extent, what does it mean? So that I'm illustrating by giving 2 illustrations. Okay. Let us say there is a trust settled where there are one of the beneficiaries is a company and there are 2 others are individuals. Okay. Now the income is apportioned amongst the 3 beneficiaries in their specified benefit sharing ratio. Now whatever share comes to the company, it will be taxed at the corporate income tax rate. And company, as we all know, there is no basic exemption, there is a flat rate of tax. Whatever share goes to the individuals, they will get their basic exemption subject to their other incomes, and they will be taxed at the individual slab rate. So this is the meaning of in the like manner and to the same extent as the beneficiaries. Let us say one of the beneficiaries is a non-resident. Let us say he is from USA. Okay. In that case, India-US double tax avoidance agreement will apply. If the trust has interest income, and if I don't remember, but let us say under the India-US treaty, the tax rate which India can levy on a US taxpayer's interest income is restricted to say 10%. So under the treaty, tax rate is 10%. Then this beneficiary will pay only 10% tax, or on behalf of the beneficiary, trustee will pay only 10% tax and not more. And then of course the beneficiary can claim a set-off against his US tax liabilities under the treaty. There is another procedure which has to be done under the income tax. You know, when the trust makes investments or the trustees make investment in securities, they earn interest or rent income or other things, there will be income tax deducted at source. Now, in a specific trust, the trust tax liability will be reduced to 0 because everything has been distributed amongst the beneficiaries. Now, what happens about the tax deducted at source in the name of the trustee? So that tax also, the trustees assessing officer should allocate the tax to the beneficiaries, and the assessing officer for the beneficiaries should give the tax credit for the amount which has been deducted from the trustee's income. This is another area where there will be a lot of practical difficulties, and because of such difficulties, as far as practical, the trustee may rather invest in tax exempt securities and keep the money in a fixed investment so that there is problems are minimized. Friends, I have already received 2 queries. Both the queries I will answer at the appropriate time. If there is any other query, please put your queries in the question box and I will try to see the queries. Now, continuing with the procedures under income tax law. Let us say the assessing officer passes an order on the trustee and he recovers tax from the trustee. Okay, that is his option. The assessing officer has two options, either to tax the trustee and recover tax from him, or to directly tax the beneficiary and recover the tax from the beneficiary. In a situation where the tax has been recovered from the trustee can recover the same from the beneficiaries. Now we come to the discretionary trust, which has been a major tool for tax planning. Okay. Now, because people have done a lot of tax planning, the discretionary government has come out with a lot of anti-avoidance provisions. We will see both. Why discretionary trusts were settled, that I have already explained, because in case of a specific trust, the income of the trust is again divided amongst beneficiaries. So it is added to the income of the beneficiaries. Then it does not become a separate legal entity. It does not get a separate tax exemption or a basic slab rate. That is why people were settling discretionary trusts. Okay. Now, in a discretionary trust, the shares of the beneficiaries are unknown or undeterminate. Okay. Now, when it is unknown or indeterminate, how do you add the income of the trust to the income of the beneficiaries? It is very difficult to, it is impossible to add the income to the beneficiaries. And that is why what government has said is that in such a trust's income under section 164(1) will be taxed at the maximum marginal rate. Maximum marginal rate has been defined under section 2 subsection 29C, and the definition is that consider the tax rate applicable to individuals at the highest level of income. What will be the tax rate? That rate will be applicable to a discretionary trust. Now, in our case, I don't remember these things, but let us say the highest tax rate of approximately 43% is applicable when somebody has an income of more than 10 crores of rupees. Okay. Now, our discretionary trust's income is only 10 lakhs of rupees. Still, it will pay a flat rate of 43% on the entire 10 lakhs of rupees income. No basic exemption and no lower slab rates, straight away maximum marginal rate. So this is an anti-avoidance provision, and ultimately, of course, the tax is suffered by the beneficiaries. Then there were different kinds of planning. People said that, okay, in the trust deed, the discretion has been given to the trustees. However, every year in the beginning of the year, the trustees will take a decision that current year's income we will distribute among the beneficiaries, say equally or in a specific ratio. And then the trust claimed that maximum marginal rate should not be applied to us. Some judicial decisions were there. They said, yes, now that the trustees have decided the MMR should not be applied. So the government has amended the law, and the law says that the specific or determinate profit sharing or benefit sharing ratios should be provided in the trust deed itself. A determination of the rate or profit sharing ratio later on is not acceptable. Okay, so why do you need discretionary trust? Now, for a moment, if we ignore the tax planning, then why should anybody settle a discretionary trust? Now, there is a practical bona fide need for discretionary trust also. Let us say there is a father, he is aged, say 35 years. He is very rich and he has certain children. Okay, he settles a trust. Now, father does not know how his children will grow in their career. One child may become extremely rich, another child may be middle class, a third child may be actually in poor class, or he may be unemployed. or one child may go abroad for a very costly education. Other children may study within India and they don't need too much of money. So depending upon the needs of the beneficiary, the trustees should be able to distribute the income or even trust fund. That is the concept. As the beneficiary's needs change, the trustees should look at their needs and accordingly they should apportion the trust income. In such a case, a discretionary trust is a bona fide means. It's a bona fide instrument. Okay. However, as I have said earlier, very few people care for such things because if there are varying needs of different children, ultimately parents will take care of it. You don't need a discretionary trust for that. So essentially, it was being done to create separate taxable entities and get these benefits of lower slab rates. So government said maximum marginal rate. Now we are considering, I will very briefly touch upon this issue of Fema because Rutvik has already covered everything. Let us say a non-resident, there is a family in India, there are relatives abroad, and the non-resident uncle settles a trust for the Indian resident children. Okay. If it is a specific trust, then under sections 4 and 8 of Fema, the beneficiaries are required to demand their share from the trustees, and whatever is their share, they are supposed to bring it back into India, period. They cannot keep the funds abroad, except if they make an application to Reserve Bank and Reserve Bank permits them to retain their share abroad, then they can continue to keep it abroad. But that kind of permission is not likely, which in turn means that even if a non-resident uncle settles a trust abroad out of his own legitimate funds, still if he settles a specific trust, then the Indian resident beneficiaries will have to bring those funds into India. Now the non-resident uncle may not be happy with it. He may want, because let us say we take illustration of US uncle and Indian family. The US uncle may feel that his money is better safe in USA because Indian rupee keeps depreciating every year continuously. So why allow the depreciation of principal itself? Let him keep the funds abroad. But if he settles a specific trust, then that option will not be available to the beneficiaries and they will have to bring the money into India. And that is why the non-resident uncle will settle a discretionary trust. Okay. Once he settles a discretionary trust, he will be able to say, and the Indian resident beneficiaries will be able to say that our right in the foreign trust are not determined. How do we know? In fact, we have no entitlement to bring the money into India. And thus the provisions of Fema would be frustrated. Okay. Now note here a point that, in fact, some people have made certain serious mistakes. Say non-resident uncle settles 2-3 different trusts. One trust for his US beneficiaries, second trust for his Indian beneficiaries. So in the second trust, all the beneficiaries are Indian residents. In such a situation, even if the trust is a discretionary trust, Reserve Bank can tell the beneficiaries that all of you collectively act and you collectively instruct the trustees to transfer the funds to India. And then Reserve Bank may succeed in getting those foreign assets into India. That is why the correct planning is that the non-resident settlor will keep at least one beneficiary who is a non-resident of India. Now, on a non-resident of India, Reserve Bank has zero jurisdiction. I'll repeat that. The settlor is non-resident, the assets are foreign, there is one non-resident beneficiary. Okay. Now, Reserve Bank cannot give instructions to the non-resident trustees. Reserve Bank cannot give instructions to the non-resident beneficiary also. And the trustee will say, I have not decided what I will allocate to Indian residents, what I will allocate to the non-resident beneficiary. In such a situation, as on today also, legally Fema cannot be enforced. Fema provisions cannot be enforced and the trustees can keep the funds abroad. This is a part of the legality. I will come to more details about such trusts, but right now I'm just explaining the Fema provisions applicable to such a trust. So foreign discretionary trust, this is the legal planning. Settlors should be non-resident, all trustees should be non-resident, protectors should be non-resident, and at least one beneficiary should be a non-resident. Preferably that non-resident beneficiary may be a charitable trust. Normally they say the Red Cross Society is appointed as a beneficiary or some such other non-resident beneficiaries there. Now, so far whatever we discussed was legal planning. Now I am coming to illegal tax evasion, okay? And I'm explaining how today illegal tax evasion is impractical. In the past, people have resorted to it. Lot of cases have come out in that Panama leak case, HSBC leak case, and even other leakages, okay? So today, foreign discretionary trusts are just impossible to save taxes wherever there is an illegality, okay? So what people used to do is an Indian resident would transfer his black money abroad through Hawala route. Then he would settle a discretionary trust in a tax haven. He would appoint certain Swiss bankers or similar bankers, solicitors, etc. as the trustees, and that trust would hold the assets. And then the Indian businessman was very comfortable with an idea that his identity is hidden. This kind of tax avoidance measures did work for several decades, and today it is absolutely impossible. So why? Let me explain to you. First of all, under Fema, of course, when the Indian businessman has transferred the assets abroad, it is an illegal transaction. Okay, so unlike the other trust, which I said that there is a non-resident uncle who out of his bona fide foreign earnings is settling a trust, there Fema would not come in the picture. But in this case, of course, the transaction is illegal. Now, what has happened is that with the pressure of US government, under the Prevention of Money Laundering Act, PMLA laws, which today most of the countries around the world have PMLA. India has got law, America has got law, all the European countries have similar laws, excepting the tax havens. Okay. So under those laws, for several decades, it has been made compulsory for every trustee, every financial advisor, that when a trust is settled or a company is incorporated or any similar entity is settled in a tax haven, the ultimate beneficial owner's passport copies have to be given. So here in this case, the illustration which we are talking about is if an Indian resident wants to settle a trust abroad, okay, his passport copies would be available with the trustees. They will be available with the bank. No bank will open a bank account without taking passport copies. Now we are talking of international picture. One can say that in India, out of 130 crores of people, probably 120 crore people do not even have passport. Now that is a different thing. The local people, domestic bank account will not require passport. But in an international atmosphere, anybody who wants to open a bank account, he will have to submit his passport copy. Now, once a passport copy is given, then we should also know that there is an automatic exchange of information, which agreement has been signed by 130 countries. So if the passport is an Indian passport, that bank will certainly give information to the Indian Income Tax Department. The information flow has started from the year 2017. And once the information comes in the hands of the Finance Ministry in India, that will be shared with Enforcement Directorate and Income Tax Investigation Department. So there will be no practical benefit of settling any tax haven trust. Just forget tax havens, forget discretionary trust. They are no longer practical. This is a part of the income tax provisions pertaining to private family trust, which I have explained to you. This I have already covered. Okay, now we come to the anti-avoidance provisions. Now this is a separate section of my presentation. Before that, let me discuss two queries which I have already seen while these queries were posted before my presentation started. Mr. Umesh Jain has given a query that a settlor has created a trust for the benefit of granddaughters because the mother of those girls expired. The grandmother and brothers of the expired lady are the trustees. What will be the treatment for the amount invested by the trustee in the trust? The money invested is received as insurance claim. So there was a lady, she was insured, she died. The insurance company made the payment. Now that payment was was placed into a trust. Okay. Now the trust is apparently to look after for the beneficiaries or the children of the expired lady. Now what will be the taxation? So the first thing, the principal amount which is settled into a trust is not subject to income tax because it is a capital amount, and income tax is to tax income, not capital. So principal amount is free from tax. Now the query says that the trust deed has specified that it is a discretionary trust. Actually, it is a mixed trust. For the life of the trust, the income will be distributed among the beneficiaries at the discretion of the trustees. At the time of dissolution of the trust fund will be divided equally amongst the daughters who are the beneficiaries in the trust. Okay, which means that the income for the life of the trust will be taxed at the maximum marginal rate. Whatever is the income, no basic exemption, no lower slab rates, straight away maximum marginal rate will be the rate applicable to the trust income. Then at the end of the day, when the trust is dissolved, when the trust fund is distributed amongst the beneficiaries, there will be no income tax. Now, Section 56, there is an interesting discussion which I will come to separately, but my complete answer for this query is that matter ends, there is no further taxation. Now, second query is that under Section 47(3), Clause 3, transfer of capital assets to a trust is exempted. So an amount is placed into a trust. So let us say a property is placed into a trust. What will be the tax consequences? We should understand that the word transfer has been defined under Section 2, subsection 47. Okay. Now, Section 47(3) exempts the settlement. Hence, there will be no capital gains payable on transfer of a property to a trust. So far, so good. Now, let us look at the sections 60 to 61, 62, 63. These are the sections. There is a set of provisions for agent anti-avoidance planning or anti-avoidance provision. I will come to her. This section 60, not applicable, transfer. Section 62, irrevocable. Section 63. Section 63, subsections or clause B. Yeah. This clause makes a definition for transfer. This is applicable mainly for settlement of trusts. Here it says that a settlement in a trust is a transfer. Okay. So there is a separate set of provisions when such settlement may be subject to tax. So what are those provisions? These are all, as I'm saying, these are anti-avoidance provisions. And but then before answering the query, let me explain here the anti-avoidance provisions. Okay. So there is one set of anti-avoidance provisions where the asset as well as the income from the asset are clubbed in the hands of the transferor. Okay. The first provision is where now you may not appreciate these provisions today because nobody does it today, but there were times when people would settle a trust. They would say, I will continue to be the owner of the property, but the income arising from the property will go to the beneficiaries. Okay, now these were all the issues when there were very high tax rates. Okay, now the law said that if you are only transferring income without transferring the asset, then under Section 60, the income would be taxed in the hands of the transferor. So that planning was plugged. Then there was a separate section. What some people said, okay, I'm transferring the asset as well as income, but at my desire, I can revoke the transfer. Revoking the transfer meaning the original transferor, if he so chooses, he will take back the asset. Now, in such case, if there is a revocable transfer, then that will be the income from that asset will be taxed in the hands of the transferor. The tax planning will not work. Section 62 said, what happens is, let us say a father settles a trust for the benefit of his children. Okay. Now, father is worried that in case something happens to his child, maybe let us say his son, okay, then his wife gets remarried, will she take away the property? Okay, I'm just giving an illustration. There can be any number of suspicions in the minds of the transferors. Okay, so father will say, okay, I'm settling my assets or I'm transferring my assets to Mr. So-and-so, my son. However, in case he dies, then I will revoke the transfer and take back the asset. Okay. Now, in such cases, as long as the transferee was alive, the income would not be taxed in the hands of the transferor. Now we come to the real, meaty provision. Here it defines revocable transfer, and there is a lot of controversy can depend upon this. I feel many people who settle trusts ignore Section 63, and dear friends, I would request you to study Section 63 thoroughly before you advise your client to settle a trust. A transfer is considered revocable under Section 63, Clause A, Subclause 1, when there is a provision for retransfer, directly or indirectly, wholly or in part. Okay. In such a case, that transfer will be treated as a revocable transfer, and once it is treated as a revocable transfer, the income arising from that property will be taxed in the hands of the transferor. Okay. Now I am posing a query for you. There are judicial decisions on that. My view is slightly different. With highest respect to the judiciary, my view is different. So I'm posing the query to you. When the settlor himself is also a beneficiary, okay. Now, so the trust deed makes a provision that the trust income will be shared among beneficiaries in such and such portion, and at the time of dissolution of the trust fund will be shared amongst the beneficiaries. Now, would you not say that the settlor has made a provision in the trust deed whereby at a future point of time, either a part of the asset or the whole of the asset can be retransferred to the settlor? Now, it will not be retransferred to the settlor in capacity of settlor, but it will be retransferred in capacity of beneficiary. A possible view, and in my submission, it is a revocable transfer. There are judicial decisions which say that it is not a revocable transfer. So we are in a controversial issue. But if it is held to be a revocable transfer, the income arising from that asset will be taxed in the hands of the settlor. Now there is another definition. Section 63, Clause A, Subclause 2, when a transfer will be considered to be revocable transfer. If the transferor, in our case, let us say settlor, has a right to reassume power over the asset, okay, whether directly or indirectly, on the whole of the asset or part of the asset, then such a transfer will be treated as revocable transfer. Now let us say the settlor himself is a trustee also. Now would you not say that the settlor has a power over the assets? It is not, the section does not require that the settlor should enjoy the benefits of the property. It simply says he has a power over the asset. Again, one stand can be, and in my submission, the trustee has a power over the asset, and hence it should be considered as a revocable transfer, in which case the income from the property will be taxed in the hands of the settlor. The contrary view is the settlor has no power over the asset, but the settlor in the capacity of the trustee has power over the asset. The two capacities are separate and hence it should not be treated as revocable transfer. In my submission, this second view on the position, I do not agree with that. Meaning, when the settlor is himself either becoming a beneficiary also or a trustee also, he should be prepared to pay tax on the income. He cannot avoid the tax on the income. There is no other serious consequence. Before settlement also he was paying tax. After settlement also he will continue to pay the tax. So it will not work as a tax planning method. If somebody is settling a bona fide trust for his children, he doesn't mind paying tax on the income, then it is perfectly okay. This is the definition of transfer. Here, see, under section 47(3), settlement has been excluded from a taxable provision. But section 63B specifically provides that a settlement shall be considered as a transfer. So if a settlement is considered as a transfer, then can you say section 56 will apply? Now this is a controversial provision. Now after a long research and discussions with my partners, I have come to certain views and I'm telling you my views. Prima facie, yes, on settlement section 56 can be applied. However, under section 56(2), sub clause 10, there is a fifth proviso, and under fifth proviso again there is a clause 10 that is exempting settlement from the provisions of section 56. This exemption is subject to the condition that the settlor is an individual and he has settled the trust exclusively for his relatives. Then I am discussing up to this, then it is exempted from the provisions of section 56. Now friends, we must remember that when the law gives a specific exemption, it only means a clarification. In this particular case, it only means a clarification. Exemption does not necessarily mean that the original transaction was subject to tax. And I'll elaborate. So we consider all these three sections together. Under section 2, subsection 31, trust is not a person. So settlement is not a transfer to the trust. It is a transfer to beneficiaries. This should be abundantly clear. Earlier also I have said trust is not a person. So what do you transfer to a trust? Trustee is a legal owner, but the beneficial owner is the beneficiary. So actually in all substance and even under the law, transfer is to the beneficiaries. Now, when the beneficiaries are closely related as per the definitions under the law with the transferor, then by definition section 56 will not apply because transfer to relatives has been exempted under section 56. Distribution to beneficiaries. Let us say this trust has been settled, because settlement of trust is one transfer. Distribution is another transfer. Okay. Settlement we have examined. Now we talk of distribution. Distribution to beneficiaries, first of all, is not deemed to be a transfer under section 63B. Secondly, a beneficiary receives what is already beneficially owned by him. It is not something which he receives without consideration. He is receiving what is owned by him. So again, 56(2)(10) cannot be applied. There is no receipt, and section 56 provisions will not be applicable where a bona fide trust is there. The settlor and the beneficiaries, or the transferor of assets and the beneficiaries, are closely related. In case of a discretionary trust, can you apply the argument? Well, if all the beneficiaries of the trust are relatives of the transferor, then yes, 56 will not apply. But if even one beneficiary is not a relative, then there will be benefit of relatives. So if it cannot be said, then that exemption will not be available. Even then, there can be further lengthy arguments, but then we are entering into deeper controversial areas. Okay. So far we have discussed anti-avoidance provisions where the income from the transferred assets were clubbed in the hands of the transferor. Now this is a separate set of anti-avoidance provisions where income from the property is to be clubbed in the hands of the spouse. We are all aware that when the husband makes a gift to wife, then the income arising from the gifted property is to be tucked in the hands of the husband. Technically, husband or wife words are wrong. When a spouse transfers the asset to his or her spouse, then it will be clubbed back. Now that clubbing provision includes the words directly or indirectly. So husband, instead of giving a gift to the wife, he settles a trust and a portion of the trust fund goes to the wife. Then very clearly, it is an indirect gift to the wife, and the income of that property, to the extent it belongs to the wife, it will be clubbed back in the hands of the husband. So this is the clubbing with the spouse. Then gift to a daughter-in-law, you are aware that there is a similar provision under section 64(1)(6). It will be again taxed in the hands of the father-in-law. Section 64(1)(a), clubbing with parents. Now here, anybody makes a gift, anybody transfers assets to a trust where minor children are entitled to the benefits of the trust, that income will be taxed in the hands of the parents. Now let us say, uncle transfers his asset for the benefit of his brother's children. Okay. Now the children are entitled to X amount of income from the trust. Now that income will be taxed with the children's father, not in the hands of the uncle. So essentially, cross gifts and other kinds of plannings which were happening, that is also prevented. Indirect cross gifts, that is avoided here. So the third set of anti-avoidance provision is maximum marginal rate. First is clubbing in the hands of the transferor. Second is clubbing in the hands of spouse or parents. Now third is maximum marginal rate. In a discretionary trust, the whole of the income is taxed at the maximum marginal rate, so that original planning of creating several separate taxable entities is frustrated. In case where a person settles a trust, even if it is a specific trust, but the trust is doing business, then the whole of the business income will be taxed at maximum marginal rate. The whole thinking in the government approach is that normally in bona fide cases, people do not do business through trust. People settle a trust and then put the money in bank fixed deposits or government securities or other such safe investments. If you are doing business through a trust, you better pay maximum marginal rate of tax. So this is how tax planning has been frustrated. Now, this is a plan I am discussing here, foreign discretionary trusts. I have earlier discussed two kinds of foreign discretionary trust. One is a legitimate foreign discretionary trust. Second is illegal foreign discretionary trust. Now this is a third trust. Okay. Some tax consultants have devised a very complex plan, and they have canvassed this plan, and I am examining the legal provisions for that. The plan says that an Indian resident will remit funds abroad under liberalized remittance scheme. He will open a bank account, keep the funds under the bank account. Then he will settle a discretionary trust abroad. Okay, because the argument goes that once the money is sent abroad under LRS, you do whatever you want with that money, and there is no problem, no questions asked. Okay, of course that presumption does not hold good since the year 2013. There are restrictions, but let us say under this thinking, the client settles a discretionary trust abroad. Then under the trust, there will be an underlying company, because holding investments in the name of trust is a difficult period. It is a difficulty. So people incorporate a company, 100% of shares are held by the trust, and the funds are placed by the trust into the company, and then the company makes investments. So one specific plan which had come to us for our review was where a company was planning to make a public issue. The company's tax consultants advised them, the directors, to settle a discretionary trust abroad, and through the trust to hold the Indian company shares. Okay, this was the elaborate plan. I'm telling you very briefly, it would amount to some 10 pages plan. What will be the legal implications? Okay. Yeah, the further, the trustees would be the foreign tax haven trustees, solicitors, chartered accountants, etc. The beneficiaries will be the settlor and his family. So the first provision, as Rutvik has already discussed, the moment you are a beneficiary, you are an Indian resident, it is your duty to bring back the funds. Okay, so that will be one impossibility. Secondly, this will be a round tripping. And those of you who are practicing Fema would know that round tripping is a very serious issue. Reserve Bank has still not clarified. There is some draft provision about ODI, but it is still a controversial issue. In any case, for an Indian resident to settle a trust, hold assets abroad where beneficiaries are Indian resident, in my submission, such a transaction requires prior permission from Reserve Bank of India. And if you apply to Reserve Bank of India, there is no way Reserve Bank is going to permit such a scheme. So these schemes will be ab initio frustrated, and the consultants, of course, are giving a legal opinion that you can do this. So you go ahead, do everything, and then you face the situation whenever the situation arises. I think that is an irresponsible advice. You can't do such a thing, because any Fema violation is met with very serious consequences. Okay, now I'm going into another aspect. I will not go into details. This is a procedural aspect, but the substance I am saying, whenever an Indian resident is either a trustee or a beneficiary in a foreign trust, it is necessary for him to disclose under Section 139. All of you who are filing income tax returns would be aware of these provisions. If the disclosure is not made, there is a penalty. If you make a disclosure, the current practical experience is the moment you disclose that you are owner of a foreign asset or you are somehow interested in a foreign asset, there will be a scrutiny assessment. And in practice, a scrutiny assessment itself is a punishment. Now, supposing you do not disclose, okay, then, and in the past, many people, as I have discussed earlier also, they settled tax haven discretionary trusts for hiding their black money. But now, under the automatic exchange of information agreement, all the information is already flowing into India, and people who settle such trusts, they are into serious difficulties. Well, friends, actually, this is the last slide, that under the PMLA or similarly black money law, anti-black money laws, once the government comes in the possession of the passport copy of the ultimate beneficial owner, then all the whales, meaning all the discretionary trust, corporate entity, everything between the passport holder and the money, the intervening whales will be ignored, and that person who is the ultimate beneficial owner would be deemed to be holding black money abroad. I'm not saying this is my legal opinion. I'm saying this is the stand that the assessing officer will take, and then the consequences will follow. In my submission, those consequences themselves amount to a punishment. So the best thing is to avoid such tax havens and such discretionary trusts. So when I have explained so many anti-avoidance provisions, when does a person settle a trust in today's times? Now on Thursday, you would have discussed several issues of succession planning and succession of the estate, succession of the business also. So there can be circumstances, as I gave an illustration, I gave only one illustration, that the parents are aging, they are not sure to be alive till a handicapped child lives. So in this situation, it is a bona fide requirement to settle a trust. But in such a situation, the parents are not doing tax planning. They are meeting a genuine bona fide need of the family. Then of course you go ahead and settle the trust and you pay the taxes. But as a matter of tax planning, today trust is not an instrument. Many thanks, friends. I will close my presentation here and I'll have a look at the questions and answer if there is any questions.
Sir, I have a question. When it's
Yes, please.
basically formation time question. So when the
Yes, please.
in case of immovable property involved in a private trust, so stamp duty is, I think, is liable to pay. So
Correct.
when the settler and the trustee is one and same, then that stamp duty is required, the transfer is required.
Yeah, I will not be able to answer. I think best thing is to ask a solicitor. Because I don't practice stamp duty law. Prima facie, people I know that big solicitors have advised settlement of trust and people have paid very huge amount in stamp duties. So, but
Okay.
see, since it is a matter of stamp duty, I will not give an opinion on a public platform. The person who can advise is a solicitor.
Okay, sir. You mentioned that anti-avoidance provisions, when in case of a settler and the trustee one and same, so it amounts to revocable transfer.
Correct. Correct.
And if he was, suppose he's not a trustee, is a beneficiary, again it amounts to revocable transfer.
Correct.
But
Absolutely right.
in majority of the cases, people like doing like that only. So how
Yes,
exactly it is?
right. So, see, actually the trust does not become void. Trust remains a bona fide trust. Now, when the settlor, let us say settlor transferred 10 lakhs of rupees in a trust, okay. Now, before settlement of the trust, he was paying tax on the income arising from that 10 lakhs. After settlement of the trust also, he will continue to pay tax on the income arising on the trust fund. Okay. So the income tax planning will not work. Otherwise, under the Indian Trust Act, the trust continues to be a valid trust.
No, there is one more advantage people see in the trust to protect the assets also, because he is in a business of very risky business. So he
Yes.
created a lot of assets. Some assets he wanted to protect in a trust form for his family's benefit. Whether
Correct.
if he is a revocable transfer, then the creditor also has a right in such assets.
No. See, this
He's a
section
trustee then.
63 definition is exclusively for the anti-avoidance provisions under the Income Tax Act. Okay. This definition would not work under the insolvency law. Okay. So it will not be a, so if let us say somebody transfers today, a businessman, in fact, in business, there is always a risk. So even if he has no bad intention, it is advisable that a businessman transfers some money in the name of family members, either directly or indirectly through a trust. Okay. Now, if he is also a beneficiary as well as a trustee, okay, then what happens is, first of all, the definition of revocable transfer will not work as far as insolvency law is concerned. If after settlement, more than 2 years I had read insolvency law many years back. I don't remember, but when I read, there was a 2 years period that after gifting a certain amount, if the person does not go insolvent for next 2 years, then that gift is valid. It cannot be called back. Okay. But that is a provision under the insolvency law. My point is, once a trust is settled and the asset is transferred, this protection from business risk will work. It should work, and section 63 will not come in the way.
Okay.
It
is only for anti-avoidance provision only. That is for the income tax point of view.
Correct. Correct.
No, in insolvency provision, one more, if you are able to help us. So suppose the settler himself also the beneficiary there.
Okay.
Suppose he become insolvent, whether his portion of benefit, whatever the share in the trust, is liable to be attached?
Yes, sir. Yes. Let us say there are 5 beneficiaries and there is a specific rate. Okay. each beneficiary is entitled to 20%. Now this businessman has gone insolvent, he is entitled to 20% share. Then that share can be called upon by the creditors.
Okay.
But if it is a discretionary trust, then you don't know what is the rate, what is the benefit going to the businessman. So then the creditors will not have access to a single rupee. So
Okay.
against business risk, this trust planning will work.
Okay, sir. Thank you. That is also one of the reason people, the business people are going for the trust
Yes,
format.
yes. Yeah. They should actually, especially, just to give an illustration, people who are brokers in the share market or they are speculating in the share market, they will see rosy picture that my money is going to double and the money may go to half. Okay. And if they have leverage, then they will go insolvent. Okay. Now, so anybody who is in a risky business should ensure financial stability of the family. First, the best thing will be to give the money to his wife. Okay. But then he may doubt that his wife may take divorce. Okay. So then he will settle in a trust and keep the money in the trust so that at least family is secure.
Yeah, suppose it's advisable not to become a beneficiary, not to become a trustee. If there is some trustworthy people is there, make them trustee and do that.
Make the wife as a trustee.
Yeah.
I mean, I said the suspicion is one in laughing manner. In India, 90% of the families don't take divorce. Okay.
Yeah.
So in 90% of the cases, it would be a bona fide issue or arrangement to make the wife herself a trustee, and then you avoid all the risks. Correct.
Thank you, sir. Thank you.
Achha, let me see if there is any question.
There are two questions there, but it is more towards charitable trust. We're able to help.
No, charitable trust. In fact, I'm thoroughly ignorant. Here is a query.
Query is, I'll read out, sir.
Yeah, okay, please.
Can a NRI be a member in a charitable trust? If no, is there any other way? That is the one question.
Okay, so I have advised in this manner to some people. Okay, so let me say, what do you mean by becoming a member? What probably the querist wants is the NRI wants to be a trustee in the trust.
Trustee, yes.
Correct. Yeah. So we had some cases where NRIs, they are desirous of donating a huge amount in favor of Indian poor people or Indian temple or things like that. But at the same time, they want to be trustee. Now here, I'm not giving expert opinion, but I'm telling you my practical knowledge. Not expert opinion because I don't deal with charitable trust law. The point is, there is a Foreign Contribution Regulation Act. Okay, that is FCRA. Under FCRA, any foreigner cannot become a trustee in a charitable trust without obtaining permission from the Home Ministry. Okay. Now that Home Ministry permission is difficult, and it is better that it is quite likely permission will be denied. That is one issue. Secondly, under Fema, as Rutvik has discussed, there is no definition for a trust. So when you have a non-resident trustee and Indian trust, what the trustee can do, what he cannot do, the entire area is controversial, vague, the law is blank. Normally we understand that the law would be complete, but Fema is a classical illustration where there are gaping holes. It is complete in some respect, absent in some other respect. So you are getting into difficulties. Ideally, the NRI should not become a trustee on an Indian trust. Then he avoids controversies. But let us say I'm talking of a case where an NRI wanted to settle $10 million. Okay, almost 70 crores of rupees. Now he does not want to give it away in the hands of somebody else. So what is the practical solution? So in one particular case, I had advised my client that you settle a charitable trust in a tax haven. Let us say the NRI is a resident of USA. Okay. Now this entire $10 million is declared in his income tax records. It is white money, legitimate. There is no problem. Fine. Now this $10 million he will put in the tax haven trust. There he will be trustee. He will be in full control of the trust fund. Okay. Now there will be a parallel trust settled in India. In that Indian trust, he would put only 10 lakhs of rupees. And some Indian residents will be appointed as trustees. The NRI will not be a trustee there. Okay. But he will be observing the performance of the Indian trustees. So as and when the Indian trust needs money, the tax haven trust will send the donation. It will be out of the income from the $10 million. The principal will never come in the control of the Indian trustees. They will get money as and when required. So that way, a control over the funds can be in the hands of the NRI, and the whole solution can work out.
Yeah, there again, I think FCRA permission is required. So for the
Yes, or
trust
receipt of donations from abroad, permission will be required. That is true.
Yeah.
But the NRI would never become able to become a
trustee, and the whole that capital amount will be remain safe
Correct.
abroad.
Yes. Correct.
Yeah, that question continues. He says NRI wants to start a trust by transferring temple to the trust. I don't know how the transfer of temple to the trust, and will be using the temple receipts and donations for general public for welfare. Can you please help me to understand the legality involved in this?
So you see, this is also very common because say one Mr. Iyengar, okay, his grandfather had settled a trust. He had built a trust. So before 70 years, 80 years, nobody bothered. So it would be property of grandfather. It would be a temple. But the whole village will come to the temple. Everybody, there will be a pujari and everything will go on. And they would be receiving donations. Now the grandson of Mr. Iyengar has gone abroad. He has become non-resident. And the grandfather and the father expired. So he has become the owner of the property. Now what will he do? The NRI, what will he do with the temple in his personal name? Okay. And if it continues in his personal name, then eventually it will be subject to inheritance tax in USA also.
USA, okay.
Yeah. So he wants to divest the ownership of the trust, ownership of the temple. So of course, some Indian residents can settle a trust. There will be Indian resident trustees, and the NRI will transfer his ownership of property of the temple to the trust. So that way the property will be divested. Then it can be a religious charitable trust. Other procedures can be complied with. If the NRI is neither a trustee nor a beneficiary in the trust, then the other Indian resident trustees can continue to operate the trust. Right?
Excellent, sir. You said you are not practicing charitable trust. Okay, thank you very much. I think we covered all. So people are asking this PPT. Yes, for the information of attendees, I will ask our person to mail, because a very limited number joined this session. I will mail the PPTs of both the days, other day and today's, to all of you. Then this video recorded will be uploaded in the Bangalore ICAI YouTube, so you can access that. So I think we covered all the questions, sir. Anything else?
Great.
Any other questions, friends? Please post immediately. Our time is up. I think another 7 minutes. We can make use of expertise knowledge. So instead of leaving 7 minutes.
There is a query, I think, Mr. Sethi.
Yes, sir.
Company has created private ESOP trust.
Okay.
And trust has subscribed to the shares of the company. Now settlor and trustee are the same. No activity. Sorry, there is some. Can you read, Mr. Sethi? There is some. No
now one has come, sir. That is in a chat box. No, in question also there are some. I'll just read in chat box also. If a trust deed which has a mechanism which guides how to arrive at the beneficiaries' ratios, then can it be called a non-discretionary trust? The name of the beneficiaries are not known at the time of settlement.
Yes, because the language of the law is the benefit sharing ratio determinate or indeterminate? It's a very interesting word. Determinate meaning something which can be arrived at, something which can be determined. It doesn't say that you must have specific straightforward rates like 20%, 20%, 20%, or 20% and 50% and things like that. That is not necessary. If you are providing a formula, okay, because many families, the grandfather is alive, he has got 3 sons, he has got several grandchildren, so he would put up certain formula. That is perfectly okay. It should be a workable formula, then it will be still treated as a non-discretionary trust or a specific.
Yes, sir. There are 2 more questions.
Haji.
Could you please clarify whether the income of a trustee is taxed, trustees or beneficiaries? It would be helpful if you can explain with an example. In your example, it is mentioned trustee and beneficiary will be taxed. Hence, would like to clarify. Yeah.
Okay.
That is from Shantaram Nayak.
Yeah, essentially, it is always the beneficiary who is to be taxed. Okay. Now, in practice, it sometimes becomes, impractical, difficult to compute the tax of the beneficiaries, because if you have, say, 4 or 5 beneficiaries and the trust has earned income of several different kinds, then it is difficult. So they pass one assessment order in the name of the trustee, but the trustee is taxed in the like manner and to the same extent as the beneficiaries, which means ultimately the tax is always suffered by the beneficiary alone. The trustee does not suffer a single rupee loss in his capacity as a trustee. It is always the beneficiary who is taxed. Now, it is possible sometimes that the trustee himself is also a beneficiary. That is fine. To the extent he is beneficiary in his capacity as beneficiary, he will suffer tax. But in his capacity as a trustee, he does not suffer the tax.
So in that case, sir, if a trustee files the return and shows all the distribution to the beneficiary, and finally he makes his tax liability is 0, and all the other individual associates filing their return and showing the proof, that suffice the compliance?
Yes, correct. Absolutely right.
In case of discretionary trust, trustee itself has to pay at maximum marginal rate.
Correct.
Tax needs to be paid there, and the distributed amount is tax-free in the hands of the beneficiary.
Correct. You are right.
Yes, sir. Then one more question. Please say something on taxation of unregistered charitable trust. How unregistered charitable trusts are taxed, as AOP or at MMR?
I don't know. Sorry, I don't know.
Okay. I think that's all the questions, I think.
Okay, great. I'm happy we are completing in time.
Yeah, we completed in time, and all the questions well answered in detail with the examples. Thank you very much, sir. We had fantastic, wonderful session we had from both of you, Rutvik and you, sir. Thank you very much on behalf of Bangalore branch.
My pleasure, sir.
Thank you, sir. Divya, are you there?
I'm there, sir.
Yeah, please propose formal vote of thanks. We had a fantastic session.
So, dear members, I take this opportunity on behalf of Bangalore branch to present formal vote of thanks for today's program. Wholehearted thanks to Rashmin Sanghvi sir and Rutvik Sanghvi sir for giving an excellent presentation. Thank you, sir, both of you, for sparing your valuable time, giving such a good session, and also clarifying all our doubts. Thank you, sir. Thank you so much.
Thank you very much, sir. Thank you. Sir, please mail us your presentation to us, sir. Rutvik, sir.
Yes.
Presentation, please mail it to. Okay.
Yes.
Thank you, sir.
Okay, bye.
Thank
Bye,
you,
sir.
sir.
Bye. Thank you very much.
Thank you,
Bye.
sir.
Thank you, Divya. Bye.